Hey, Charlene. Welcome back. Good morning, everybody. How are we doing?
Judge, we're just showing Mr. Martin some photos that we're going to be introducing as composites as well for you.
Alrighty. Let's see, who all do we have today? We have Mr. Rosenwasser, Mr. Martin. I don't see Mr. Garcia yet. Oh, he is there? Oh, okay. We have Mr. Escobar, Mr. Funderburg, Mr. Michaels, Mr. Reeves is present, Ms. Flores.
For this business, you have to have a sense of humor.
They all have March on them, so we February.
On the date?
Yeah, so say we all.
Oh. Okay, I'll fix that. Actually, I have to go back to my office to fix that.
Yes, sir.
I can't fix it from here. All right, so other than the date, everything else is okay?
Yes, sir.
Okay. I'll be right back. When I come back, we'll bring it here.
And Your Honor, I sent the court a copy of the motion rights and documents.
We'll deal with that right after the jury goes out.
How you got here?
Sure, sorry, any comments?
Oh, I have that. I have that. Thank you.
sir.
Okay, we're back. You may be seated. You should have the verdict form, copy of your verdict form. You know, that's it. And everyone should have a copy of the jury instructions. So I'm going to bring the jury in and begin. We'll get the jury.
Yeah.
That's already on. Oh, yeah, okay.
Yeah, so the jury gets in.
Oh, just for the record, the alternates are they're all seated in the back row.
Matt, can you go back and stop, you know where I would like you to stop on segment 2? Okay. Can you go back a tiny bit, Matt, and stop? There. Mr. Koenig, this is obviously after the shot has been fired. Did we ask you to get some PNGs, meaning some individual files, to focus on those particular areas?
Correct. Still image files, individual images like this one were pulled off separate.
Okay.
That would have included this there.
Okay. And for this particular area, so the focus that you had on those PNGs?
That's correct.
Go ahead, Matt, please. Okay, stop there, Matt. Mr. Koenig, please tell ladies and gentlemen of the jury what they're about to see in this particular segment of the video.
Okay, this segment is again magnified like the last one. It's enhanced, and again, that means the darker areas have been lightened. It's been sharpened a little bit, and the contrast has been improved. So,
Go ahead, Matt. Stop there for a second, Matt. Again, Mr. Koenig is at an area that we asked you to focus on with reference to some PNGs later on in the presentation here.
Yes, we pulled off still images of this area.
Go ahead, Matt. Mr. Koenig, would you please describe to the ladies and gentlemen of the jury what they're about to see in this particular segment of this particular video?
Yes. Very much like the last one, it's enhanced, magnified, 200%, but it's now centered on that area you designated.
Go ahead, Matt. Go through, Matt. That's fine. I'm not going to have you stop it. Okay, Matt, please stop. Mr. Koenig, again, what are we about to see here in this particular segment of the video?
Okay, this is the same as the last, enhanced, centered on an area, but now the magnification's been increased to 400%.
Okay, go ahead, Matt. Run it back again, Matt, please. You don't have to stop it. Okay, Mr. Koenig, let's talk about what the ladies and gentlemen of the jury are going to see now with reference to this segment.
Okay, this is going to be a smaller section of the last area you've been looking at, the smaller side. Again, the larger magnification is enhanced, and now it's going to play back at 1/2 speed.
Okay, man, you can stop it there. And so that was a segment that was requested by us. Is that correct? And so that 50% playback and that magnification was on that particular area that I was circling here earlier on. Is that correct? Okay. Matt, can we do that one more time? Okay. Please tell ladies and gentlemen of the jury what they're about to see now. I believe this is the last segment of this particular video. Explain to them what you've done in order to be able to play that particular segment. this, please tell the ladies and gentlemen of the jury what they're about to see in this particular segment of the video.
Again, enhanced video, shorter segment than the big segment we reviewed at Chad. 100% magnification, except we want the whole screen. Playback speed is now at 1/4 speed, 1/4 the back to playback.
Go ahead. And Matt, you don't have to stop on this one, you can go right through, okay? I think we're good, Matt. Mr. Koenig, I'm going to show you what's been marked as defense exhibit number DD, and ask you if you recognize that particular exhibit.
Yes, sir.
And did you view that exhibit, and did you sign it and date it?
I did.
Okay, and did you view that exhibit in an effort to determine whether that exhibit had a fair and accurate representation of the contents of Q6?
Yes.
Okay. Now we remove exhibit DD into evidence.
All right, it'll be admitted as number 6, defense 6.
Go on, you see. Now, Mr. Koenig, this exhibit is broken down into folders, is that correct?
Correct.
Okay, and tell the ladies and gentlemen of the jury what they're about to see. Are these PNGs?
These are going to be still images from the video.
And those still images were extracted from that Q6,
Correct.
and they were placed in a folder.
Yes.
And that folder was called,
Well, I think you're having various folders here, like 13/26/25 to 13/26/26.
gotcha. But these are PNGs, am I
They're
correct?
still images of the video you've already seen. These are just the still images of it.
Okay. Matt, can we please go to folder number 1? Stay right there, Matt, just for a second. For these two areas of interest for the defense that we wanted you to capture in a still image in this particular exhibit.
Yes, sir.
Go ahead, Matt, you can run through them. Now, each of those movements is Mr. Funderburg actually moving the cursor to go to each image, is that correct?
Correct.
Okay. Matt, you can go backwards. Next folder, Matt. Matt, let me know and I'll do that for you. Okay, Matt, go through the individual frames. Same in this folder, and Matt, you can stop it now. Same in this folder, you have individual frames that we're viewing in this folder from the Q6 to the areas that we had requested. Is that correct?
That's correct.
Okay. Next one, Matt. Do you want a whiteboard? Okay. Sorry, Matt. Now, this particular set of images have been magnified and enhanced, is that correct?
Correct. And looped.
And looped, okay. Go ahead, Matt. Stop right there, Matt. These particular images, you're able to tell by the time stamp that we have what image goes in sequence, is that correct?
Correct. This particular video actually has embedded in the data out to that number. It's a number we made up or manufactured. That's actually in the data itself. So we know exactly that if it's 30 frames per second, it means each frame is about 1/30th of a second, or what we call 33 milliseconds apart.
So if you're looking at this number right here, as they go up and down, you'll be able to know the order of when that particular event happened.
That's correct.
Hey, Matt? Oh. Go ahead, Matt. in the last folder, Matt, in that exhibit. Now, let's go to the beginning of that again, and then stop it at the very beginning. Okay. Mr. Koenig, this number right here, as it gets higher, this is the first event in the image, is that correct?
So then you designate.
Yes, that I designated. And then as it goes higher, it's later frames from that frame, is that correct?
Yes, it's in time, serial. This is what the video you want already. It's just, these are the individual images that make up the video itself.
Matt, go ahead. Okay, Matt. Mr. Koenig, I'm going to show you what's been marked. But before we get to that in just a second, Matt, let me have DD1. Might as well do it right when we're at it. May I approach you on it? Mr. Koenig, I'm going to show you what's been marked composite exhibit DD1, coming from exhibit DD. Did you take a look at those composite and compare those composite exhibits to the exhibit DD to make sure that those fairly and accurately depict what was contained in that DD exhibit?
For these 3 frames,
Yes, for those 3 frames.
portions of those 3 frames, I should say.
Yes.
Yes, sir, it does.
Okay. Your Honor, we would, at this point in time, introduce DD1 as a composite exhibit, and we would ask for permission to publish it to the jury.
Any objection to the admission of number 7?
No, no.
All right, it will be admitted as offense number 7.
Koenig, I'm going to show you now what's been marked as Exhibit JJ, and ask you to take a look at Exhibit JJ and see if you recognize Exhibit JJ.
Yes, sir, I recognize it.
And did you review the contents of that particular exhibit and compare it to what was contained in the Q6 hard drive that you received? That was the hard drive imaged from the Cobb theater.
I did.
Okay. And in fact, does it fairly and accurately depict those images that are contained in the Q6 hard drive?
Yes, sir, and I have initial images.
Thank you. May I approach? Your Honor, we would be admitting Exhibit JJ.
JJ, we admitted it's number 8.
And may I publish it?
You may.
Now, Mr. Koenig, likewise, these are individual files, is that correct?
Correct, again, still images of videos, frames, that's what we call them.
These were areas that we had asked for you to do that in order to be able to focus on that particular area.
Yes, sir, that's correct.
I'll get that. Okay, Matt, go ahead. One more time, Matt. And again, Mr. Koenig, as these numbers get higher, those are the later frames.
That's correct.
They start from the lower number and progress to a higher number on the milliseconds. Is that
And they're
correct?
1/30th of a second apart.
Next one, Matt. You want me to turn it off?
No.
Okay. Now, this is a different segment of the video, is that correct?
Yes.
Okay. Go ahead, Matt. Stop there, Matt. We want you to focus on this particular area in these particular images, correct?
Correct.
And so each, again, the lower images to the higher images show the progression. Is that correct?
Yes.
Do it again, Matt, please. Stop there for a second, Matt. Now, Mr. Koenig, you realize that the cameras were up 30, 35 feet into the theater, is that correct?
Correct, up on the wall.
You went to that theater, is that correct?
Yes.
And are you going to have a different perspective with the camera 35 feet up than someone that's seated in, for example, this seat 9, where Mr. Reeves was seated?
Yes, but definitely it's a different perspective. If you're looking at me here and there's a camera over there looking at you, it'll show the same actions, but from a completely different direction.
Go ahead, Matt. And then we can whiteboard it. Yeah, we have those. It's JJ. Okay. May I approach it with you, Your Honor? Mr. Koenig, I'm going to show you what's been marked as Defense Exhibit JJ1, which is a composite exhibit, and ask you if you reviewed those particular photos, images, to determine whether they fairly and accurately depict what was in Exhibit JJ. They're just now in a hard form.
Yes, Cindy.
Then we would move to admit JJ1 in defense exhibit.
All right, that'll be admitted as number 9.
Your Honor, may I have a publishing jury?
You may.
May I approach you? Mr. Koenig, I'm going to show you what has been marked as Defense Exhibit KK, and ask you to please take a look at that exhibit.
Yes.
Did you review that exhibit?
Yes.
Did you view it?
Yeah, I did.
And did you compare that exhibit or the contents of that exhibit with Q6, which was the hard drive from the Cobb Theater?
Yes, and this is from camera 12, which is on the left wall.
And does that fairly and accurately depict what the contents of Q6 were or are?
Yes, and I've initialed it and dated it.
Your Honor, we would, at this point in time, move to admit as Defense Exhibit KK.
That'll be admitted as number 10. Yeah.
So this is, Mr. Koenig, the camera from the left side. If you're looking at the theater screen, it's the camera from the left side of that theater. Is that
The
correct?
second here would be over here.
Yeah. Go ahead, Matt. Right there, stop, Matt. Mr. Koenig, did we ask you to pull those particular images so that we could focus on a particular area of that video?
That's correct.
And is that the area that we wanted you to pull images from to focus?
Yes, sir, it is.
Your Honor, I'm going to object to the use of the video. It's cumulative evidence. If they want to admit the photographs, we have no objection to the admission of the photographs, but presenting the video over and over is cumulative at this point.
Either one on you, either.
You may.
Mr. Koenig, I'm going to show you what's been marked for defense as Exhibit P1. I'm going to ask you to take a look at that exhibit and tell me if you reviewed that exhibit and compared it to the images that were in Exhibit P, Defense Exhibit P,
Yes.
and do they fairly and accurately depict the actual images that were located in Exhibit P?
Correct.
And did those images likewise fairly and accurately depict what was in hard drive Q6?
Q6, yes.
Your Honor, we would move to admit P1,
It'll be admitted as number 11.
and we would ask that it be published.
Go ahead, Becky.
Let's move this back one more. Move this way?
I don't know, I'll see.
Let's move this. Yes. And correct. Is that okay?
To the clerk.
Please. Mr. Koenig, just a few more questions. You remember the red square that we had in some of these particular videos and images, correct?
Yes, sir.
And did we ask you to put that red square around an area of that image or of that video that was either a reflective or emitting light?
Correct.
Okay. Do you remember going with our crime scene expert to the Cobb Theater after this incident in an effort to try to find the source of that particular emitting or reflective light?
That was the object of the visit, or part of the object of the visit.
And there was a question as to whether that emitting or reflective light was either coming from a shoe or from a cell phone.
Yeah, you advised us that it could be one of those two.
Okay, and so we asked you to go to that theater with an individual by the name of Doug Lacey, is that correct?
Yes, my associate, yes,
Okay. And you were there present as well?
I was.
It was in the wee hours of the morning, middle of the night?
The theater wouldn't shut down. I think we had to go when there was no movies being shown.
Okay. And did you try, on that particular day, did your team try to see if that was even going to be possible, meaning to determine the source of that particular light?
Yeah, but we did realize that the video system had been completely changed, and they weren't even sure that the cameras hadn't been changed. We realized we couldn't do anything in the way of trying to identify where that light source would be or what it was.
One last housekeeping matter. We talked early on in your testimony in this case about the Aaron Hernandez case.
Correct.
Did you serve as an expert for the defense or the prosecution in that case?
Yeah, I made a mistake when I said it was for the government. We actually did the case for the defense.
Your Honor, we have no further questions of this witness. We will pass the witness.
All right, thank you. Be a good time for a break, ladies and gentlemen. Let's take 10 minutes. Remember my instructions during the recess and go back to the jury pool. Before we let him go? Okay, hold on a minute. The state has indicated they're not going to cross Mr. Koenig, so may this witness be released?
He's under subpoena, but yes, Your Honor.
Okay, Mr. Koenig, you're free to go, and just if you get called back, you'll have to come.
I appreciate that, Your Honor.
Thank you. And you, ladies and gentlemen, may take a 10-minute recess.
All rise for the recess for 10 minutes.
We ready to begin? Bring him in.
Jurors in the courtroom, Your Honor.
Thank you.
Jurors may be seated. All jurors are present and accounted for, Your Honor.
Thank you, Deputy. Thank you, ladies and gentlemen. Were you all able to abide by my instructions during the recess? All right, then, let's get started. Mr. Escobar?
Your Honor, the defense would call Joanna Turner.
Do you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Okay.
I'm sorry?
Just speak into the mic. You don't have to speak right into it.
Go ahead, Mr. Escobar.
Thank you, Your Honor.
Good morning.
Good morning, Ms. Turner.
Good morning.
Ms. Turner, are you employed?
No, I'm not.
You retired?
I'm retired.
And do you remember when you retired? 2005 sounds accurate?
2004 or 5.
Okay. And would you tell the ladies and gentlemen of the jury what type of business you retired from?
Airline industry.
Okay, what were you doing at the airline industry?
I was working the call center.
The call center?
Mhm.
And I believe, tell me if you agree or disagree, you were in the banking industry before that.
Yes, I was.
You were a bank manager, is that correct?
Yes, I was.
Okay, and how long did you do that?
4 or 5 years.
Okay. Now, I'm going to direct your attention to January the 13th of 2014. Can you tell us whether you went to the Cobb Theater that particular day?
Yes, I did.
Okay, and who did you go with to the Cobb Theater that day?
My husband.
Okay, are you still married?
No, I'm not.
Was your husband back then Mark Turner?
Yes.
Okay. You would agree or disagree that when you arrived at the Cobb Theater, the previews were already playing?
Yes.
You would agree with that?
Yes, I agree.
Okay, and so would you agree or disagree that when you went into the Cobb Theater, you sat in the very top row, correct?
Mm-hmm, correct.
In the very last 2 seats of that top row?
Yes.
Is that correct? So if you're looking at the screen here, it would have been that very top row, very right, last 2 seats.
Correct.
And can you tell me who was seated in the last seat and who was seated in the seat just before that? The last seat right next to the aisle, who was seated there?
My husband.
Your husband?
Yeah.
And you were seated
Next to him.
to the left?
To the left.
Okay. Was there a reason that you all sat there on that aisle?
Yes, we always sit on the aisle.
Okay, is there a reason for
Because he's
that?
got a back problem, so sometimes he need to stand up and stretch.
Okay. When you went and sat down and started to watch the previews, what were the lighting conditions at the time in that theater?
It was dim, but you can still see a little bit.
Okay. And what was the noise level? Were the previews playing?
It was loud.
Previews were loud?
Mhm.
Okay. And I'm going to try to take you through, the process of what took place. You're seated there. Did there come a time where you saw a gentleman that was coming into your row, meaning coming from the lobby area or the downstairs, coming up the stairs, and coming into your row A?
Yes.
Okay. And was that gentleman Curtis Reeves?
Yes, it is.
Okay. And so when he came into your row, was he careful in getting through?
No, I think he was, because it's so small, such a small space.
Okay.
So
And did you see him actually go to his seat?
no,
You were paying attention to what?
to the preview.
To the previews. Now, did you see anyone standing up after Mr. Reeves had passed you to go to his seat?
No, I did not.
Didn't see anybody standing up. You were watching the previews. Is that correct?
Correct.
Objection leading?
Sorry, Your Honor.
Assisting.
Do you agree or disagree that at some point in time, you saw someone standing up that was in the row in front of your row?
Yes, I did.
Okay. And can you describe that individual for the ladies and gentlemen of the jury?
Tall, slim.
And when you saw him standing up, would you agree or disagree that he was talking but you could not hear what he was saying?
Correct.
And while he was talking, would you agree or disagree that he was facing the back row?
Yes.
And he would have been facing, you agree or disagree, in the area of Mr. Reeves?
I'm sorry, repeat that again?
You would agree that he was facing the back row where Mr. Reeves was?
In that area, yeah.
Now, would you agree or disagree that while this was taking place, you were both glancing over there and then also looking at your previews?
Agree.
You were interested in those previews?
Yes.
Those previews were, well, let me ask you this question. Do you agree or disagree that some of those previews were action-packed previews?
I couldn't say. I don't recall.
You don't recall the actual previews that were on?
No.
Okay. Now, would you agree or disagree that as this tall gentleman was standing facing in the direction of Mr. Reeves, that you saw an actual throwing motion of a mug or a thermos?
Objection leading?
Agree or disagree?
Overruled.
Would you agree or disagree that you saw this tall gentleman with either a cup or a mug or a thermos in his hand, dark in color, making a throwing motion towards that back row with his left hand?
Objection, this is a leading question.
No, it's not. Overruled.
Would you agree with that?
Yes, I did. I agree.
You agree?
Mhm.
Okay. Now, would you agree or disagree that after you saw that throwing motion, your eyes went back to the previews, to watch the previews? Agree or disagree?
Agree.
Would you agree or disagree that that throwing motion that you told the juries about was a quick throwing motion? Quick.
Yes, it is.
Now, would you agree that, or disagree, that about anywhere between 4 to 6 seconds passes?
Yes, about.
And would you agree or disagree that now you hear a loud voice, correct?
Correct.
And that loud voice was coming from that tall...
Objection, leading.
Would you-
Sustained.
Would you agree or disagree that that loud voice was coming from that tall gentleman that you've just described with this throwing motion?
Agree.
And would you agree or disagree that that gentleman was still standing at the time?
Agree.
Do you remember what that tall gentleman was saying, Mrs. Turner?
I'm texting my daughter, if you don't mind, in that sense.
That's what you remember.
Mhm.
Do you agree or disagree that at that moment you looked over towards Mr. Reeves, correct?
At which moment?
After that statement was made.
No, I was looking at Mr. Oulson.
Mr. Oulson, at some point in time, did you direct your attention back to Mr. Reeves?
Yes.
And do you agree or disagree that what caused you to direct your attention to Mr. Reeves is that you noticed that Mr. Reeves was sitting kind of funny?
Correct.
Would you agree or disagree that what you described as something funny was that Mr. Reeves was leaning towards his left
Agree.
in his chair?
Agree.
Would you agree or disagree that throughout this period of time right now, you didn't hear a peep from Mr. Reeves, right?
Agree.
Would you agree or disagree that it was at this moment, after seeing Mr. Reeves kind of sitting funny, that you noticed a ring of fire and some popcorn?
Popcorn first, and then I hear the gunshot and the ring of fire.
Would you agree or disagree that you did not see any weapon?
No, I did not.
But you would agree that after the ring of fire, would you agree or disagree, that after the ring of fire, you actually saw Mr. Reeves laying a pistol on his left knee?
I believe it's the right knee.
You thought it was a right knee? One of the knees. Is that correct?
Agree.
And would you agree or disagree that immediately after that happened, that you noticed Mr. Reeves's hands going to his head?
Yes.
You agree or disagree that at that point in time you get up out of your chair?
No.
What do?
I waited until this gentleman come up to Mr. Reeves. There's a suggestion of showing a badge and hold out his left hand for his gun. And once I saw Mr. Reeves give this gentleman the gun, that's when I feel safe to stand up.
Okay, and you did. Is that correct?
Yeah, right after that, probably.
Okay. And would you agree or disagree that at that point in time you got up and then shortly thereafter you went down the stairs?
Yes.
Is that correct?
Correct.
And would you agree or disagree that at some point shortly thereafter a woman who had been injured approached you?
Agree.
And that you assisted her with whatever you had in your hand to control the bleeding?
Agree.
And would you agree or disagree that you then went to that back exit door to assist law enforcement to be able to come in through that back door?
Agree.
Now, would you agree or disagree that at some point thereafter, you joined a group of individuals that were congregating in the theater?
Yes, agree.
And would you agree or disagree that those individuals were in fact talking? The
Yes,
group?
agree.
And would you agree or disagree that no police officer ever came up to you and told you you're not supposed to talk about what happened amongst yourself? That never happened.
Agree.
And would you agree likewise that you didn't witness any police officer talking to the group, telling
Objection
them?
leading.
Sustained.
Would you agree or disagree that at no point in time did you see a police officer approaching the group you were in to say, don't talk about anything that was
I did not.
witnessed here? Now, how long were you down there in that group before you were relocated?
I would say about 10, 15 minutes.
Okay, and was your husband likewise in that group? Mark Turner?
I believe so.
Okay, and is it, would you agree or disagree that Mr. Turner was likewise speaking to individuals within that group?
Agree.
Would you agree or disagree that while you were there in that group, that a voluntary statement was filled out by you?
Agree.
And would you agree or disagree that your husband likewise within that group filled out his voluntary statement?
Agree.
And would you agree or disagree that you told your husband what you had witnessed there in that particular theater, there while you all were in that group?
Disagree.
Where did you tell him your version of what had happened?
I believe after we got moved to the theater across, and we were sitting there waiting for the detective to talk to us, I believe at that time I told him what I saw.
And you told him what you've told the ladies and gentlemen of the jury here today?
Yes.
So you went from the theater in that group to what area of the complex?
I think it's a theater adjacent to that theater.
Okay. And when you went into that adjacent theater, was there a group of individuals, lay people, patrons of the theater that were in that theater as well?
Yes.
And when you went into that second theater, were those individuals likewise talking amongst themselves?
Agree.
And would you agree or disagree that your husband was within that group of patrons in the other theater?
Disagree.
Where was your husband?
He was sitting by me.
But there, what I'm saying, in that theater.
In that theater, we were sitting by ourselves.
Okay. How many people would you say were in that second theater?
20, 25?
20, 25. In that second theater, did you hear any police officer indicate to you and your husband not to discuss your testimony amongst each other?
I did not.
In that theater, did you hear any police officer tell any of the patrons that were there in that theater not to discuss their testimony amongst each other?
No, I did not.
You would agree or disagree that the interview that you had with law enforcement, that was in a cleaning room, right?
I believe so.
And would you agree or disagree that that interview lasted about 10 minutes?
Yes.
I have no further questions.
Ross?
Thank you. Good morning, Mr. Stern.
Good morning.
You indicated that when you entered into the theater, the lights were a little bit dim,
Yes.
and even though it was dim, you could see about 5 seats away. Is that fair?
Correct.
All right, and in fact, you could see, based on the lighting conditions in the theater, up to 10 seats away. Isn't that correct?
Correct.
So although we're saying that it's dim, focusing on just the word dim, you could see 10 seats from you, correct?
Correct.
So it was light enough in the theater for you to see.
Yes.
And even though we have heard that the previews were playing, you could still hear, correct?
If I wanted to, yes.
Okay. In other words, you didn't have any difficulty hearing your husband, Mark, who was next to you, right?
No.
And you felt, even though the previews were playing, that you could hear people 5 and 10 seats away if you chose to listen to their conversation. Would that be a fair statement?
Yes.
So the reason you couldn't hear specific words or specific conversations was because you weren't listening for specific words or specific conversations. Is that correct?
Correct.
But you did hear the chattering in the theater, and you could hear that chattering up to 10 seats away. Is that correct?
Correct.
So it obviously wasn't deafening loud in the theater.
It's loud.
Okay, but you could still hear people talking 10 seats away.
Yes.
Would you agree with me that Mr. Reeves, when you saw him, he appeared to be a large man?
Yes.
You indicated that the first time you saw the defendant was when he was coming up the aisle and then walked across your row in order to get to his seat, correct?
Correct.
And based on your life experiences, the way you observed the defendant, you felt that he was rude. Isn't that correct?
At the time, yes.
And when he went through the row, he was trying to avoid people's feet, correct?
I'm sorry, repeat that again?
Was he trying to avoid stepping on people's feet when he went through the row?
My feet, yes.
Okay. But based on your observation of him, he appeared to be rude.
Well, he just didn't say, excuse me, just standing there on my right. So I just moved my feet back so he's gently passed.
Okay, but what I'm asking you is based on everything you observed about the defendant.
Object, she's answered that.
Sustained. Sustained.
I didn't hear I didn't hear your ruling.
Sustained.
All right, so you indicated that you saw the person that was shot standing up, correct?
Correct.
Okay, and did you learn his name?
Not after, not at the time, but after, yes.
Okay, and his name is Chad Oulson?
Correct.
All right. So you indicated that you saw Chad Oulson standing up, is that correct?
Correct.
And at that time, when you first saw him standing up, you thought that Chad Oulson and the defendant here were friends.
Correct.
And that's because the conversation that you were personally witnessing wasn't anything of a violent nature, so to speak.
No, it's not.
Okay? And that was the reason, based on what you were observing, that they were just having a conversation.
Correct.
It didn't concern you at that point.
It did not.
And at that time, Chad Oulson was only standing in place, correct?
Correct.
I'm going to take this in some segments. So the first time you see Chad Oulson standing, there was nothing that gave you any concern in the theater, correct?
Correct.
So at this point, when you see Chad Oulson, he was not reaching over to attack or punch or do anything to the defendant, correct?
Correct.
Wasn't making any threatening statements to the defendant, correct?
Correct.
And that's the reason why you went back to watch the previews, correct?
Correct.
Now, you indicated that at some point in time, you saw what you believed to be an object, right?
Correct.
And you said that this object appeared to you to be a thermos, correct?
Correct.
So when you say thermos, you're talking about something that you would drink out of, correct?
Correct.
Now, you'd agree with me that a thermos, or something that looks like an object you would drink out of, does not look like a cell phone, correct?
Correct.
And in fact, you could definitively state, meaning you could state with certainty that it was not a cell phone, correct?
Correct.
Now, you indicated that you thought you saw a throwing motion, correct?
Correct.
You did not see any objects thrown, though, correct?
Correct.
And the object that you were talking about seeing was this thermos, this drinking object, correct?
Correct.
At the time that you saw this throwing motion of this thermos, did you hear the defendant say anything to the effect of, ow, I was hit, anything at all like that?
I did not.
In fact, you didn't hear the defendant say anything at all, correct?
Correct.
Since you were looking in that direction, you didn't see the defendant react as if he had been hit by an object, correct?
Correct.
For example, let's say an object was thrown and it hit somebody. Generally, people grab that area of their body that they're hit.
Object is to generally people, that's totally speculative.
It's common sense.
Overruled.
If people are hit by an object, they would grab the part of their body that they were hit, correct?
Correct.
You did not see that happen, did you?
I did not.
And at that time, when you're talking about this throwing motion of a thermos, you did not see Chad Oulson jumping or going into your aisle, correct?
Correct.
You didn't see Chad Oulson virtually on top of this defendant, did you?
No, I did not.
Did you hear the defendant yelling, no, no, no?
No, I did not.
Did you hear him yelling, whoa, whoa, whoa?
No, I did not.
Did you see the defendant holding his left arm out to prevent an incredible attack that was coming?
No, I did not.
Now, although you indicated that Chad Oulson said something, you indicated that he was not yelling loud. Isn't that a fair statement?
Yes.
Okay. So although he was loud, you would say that he was firm.
Correct.
So he wasn't yelling and screaming, he was just firm in telling the defendant that he was texting his daughter.
Correct.
And you think that he even said, do you mind? Or some words to that effect.
Correct.
So at this point, Chad Oulson's just standing, facing the defendant, correct?
Correct.
And in a firm voice, not yelling or threatening, said that he was texting his daughter.
Correct.
And it's during this time that you say that you see the defendant leaning backwards or leaning to the left.
Leaning to the left.
Okay. Now, you don't know if he was reaching for a firearm at that point, do you?
No idea.
Because if he was leaning to the left at that point, the only thing that was happening was Chad Oulson was in front of him, just telling him, I'm texting my daughter, correct?
Correct.
You didn't see anything that was life-threatening at that point, correct?
Correct.
And at this point, when you said that you saw the defendant doing something, Mr. Oulson wasn't jumping into your row, correct?
Correct,
And at that point, you didn't hear the defendant yelling, "No, no, no," or "Whoa, whoa, whoa."
correct,
In fact, you never heard the defendant yelling, "No, no, no," or "Whoa, whoa, whoa."
correct,
And you never saw the defendant reaching his left hand out as Chad Oulson was virtually on top of him, correct?
correct.
Now, isn't it true that at no time, well, let me ask you it this way. Was there a female you indicated, was it Nicole Oulson, who you met with later on, who had her finger that was shot off?
Yes,
Okay. At no time did you see her fighting with Chad, correct?
no, I didn't see her at all.
Okay. So when you never saw her ever? Up until the point in time that you helped her with her hand?
Correct,
Okay. So by that answer, you're saying that you never saw her holding Chad Oulson back?
no, I did not.
You never saw her having this struggle with Chad where he was trying to get into your row, correct?
Correct,
You never saw Chad Oulson punch the defendant, correct?
correct,
At no time did you ever hear the defendant here, and I know we were talking about with the throwing of the, or the throwing motion. I'm talking about at no time. At no time did you ever hear the defendant say anything that led you to believe that he was hit.
correct,
At no time did you ever see him lean over as if he was struck by holding a part of his body.
correct,
The only time that you saw him holding his head or rubbing his head was after he fired the shot.
yes,
Let's talk about this possible throwing motion. Isn't it true that you're not even sure that you saw that?
I'm pretty sure I saw it.
Okay. Would it refresh your memory if I showed you a copy of your deposition?
Sure.
May I approach the witness?
You may.
And for counsel, I'm looking at page 73, 74, 77, and 82. Okay, first, I'm looking at page 77. Can you read lines 17 through 20 to yourself?
To myself?
Yes.
Okay.
Okay. After reviewing your deposition, isn't it true that you indicated that you weren't 100% sure?
At the time, I was telling Mr.
Well-
Escobar, right? This is,
Yes. I mean, what I'm asking you is, in the deposition, did you indicate to Mr. Escobar that you were not 100% sure?
yes,
Okay. Page 82.
Judge, I'm going to ask him to the doctrine of completeness that he read all those lines that she read because I believe it puts it in context.
If that's the case, then
I'll continue down to 24.
No, I think you started at 73, did you not?
I was at 77.
Well, you started to tell me it was 73, and there is conversation in 73 concerning the black.
Right, that was, we have to approach.
yeah.
Okay, so going back to the question, you indicated that you were not 100% sure, correct?
I'm not 100%.
Okay. Page 82, lines 22 on page 81 through line 4 on page 82. So this part right here, just read that to yourself.
Right there?
Yes. Okay, upon reading that, does that refresh your memory that you indicated, I think I saw a cup in his hand, that little throwing motion?
Yes.
So you'd agree with me, you said you think?
Mhm.
You gotta answer aloud, sorry.
Yes.
Okay, thank you, ma'am. And would you agree with me, the way you were testifying, you said the word throwing motion. But isn't it true that you actually saw something that moved real quick and not a throwing motion?
Can you rephrase that question?
Yes. The motion that you saw, was it just a real quick movement towards the defendant, not a throw?
Yeah, it's just a quick motion,
Okay, so it was not a throw.
not a throw.
And again, during this time that we're talking about, this quick movement that was not a throw, you didn't think anything was happening that you had to pay attention to, correct?
Correct,
And that's why you went back to watch the theater previews.
correct.
And that quick motion you're talking about, you didn't even think that was in a threatening manner because you still thought they were just friends.
Correct.
And you heard the gunshot after the popcorn, correct?
Correct.
Did you see Chad Oulson walk down the aisle and fall down in front of the other people?
Yes, I did.
And was that fairly quickly after the gunshot?
I think it take about 2-3 seconds when he start walking.
Okay, and then he fell at the feet of other
No, he
moviegoers?
walked like 2 steps.
Okay,
like
so
he's
after he was
gonna
shot, he
exit.
took 2 steps and then he fell.
Yes.
Have a moment, Your Honor.
You may.
I want to talk about the times after the shooting when the police became involved. When you went down by the screen after the shooting, you'd say that there was less than 20 people down there, correct?
Correct.
When you were given the written statement, you weren't given any instructions, correct?
No,
No, you weren't given instructions.
correct.
And you were asked if Mark had spoken to anybody. You remember that question?
No,
Okay, well, defense counsel asked you whether or not your husband, Mark, had spoken to anybody in the theater after the shooting.
oh, yes.
Did
Correct.
you hear what they spoke about?
No, I did not.
So you have absolutely no idea what they talked about?
No, I did not.
And when you agree with me that although the people that were in the theater were still in the theater, they were scattered around the theater,
Correct.
and you and Mark actually separated yourself from other people?
The theater across?
Correct.
Correct.
And when you filled out your written statement, you filled it out separate from your husband.
Correct.
In fact, wouldn't you say that it was very quiet with all those people for a couple of hours?
Correct.
And if other people were talking, you have no idea what other people were talking about.
No, I did not.
Okay, you did not know what other people were
I do
talking
not
about.
know.
So if you just heard some chatter, you can't say specifically what they were chattering about.
Correct.
Can I have one more moment, Your Honor?
You may.
Thank you, ma'am. I don't have any further questions.
Oh, you're welcome.
Redirect?
Yes, Your Honor. Good morning, Ms. Turner, again.
Good morning.
Ms. Turner, you remember having a hearing here back in 2017 and being placed under oath. You remember that?
Yes, I do.
Okay. Page 265, lines 3 through 6. Remember the following questions that was asked of you by me.
I have an objection as far as the form,
Yeah.
what we're doing here.
Is there a question or?
Oh, yeah, it was her previous statement that
Oh.
I am now, can we approach?
Yeah.
Will you show the ladies and gentlemen of the jury what you meant by a throwing motion? You would agree or disagree, it was Mr. Oulson's left hand, correct?
Correct.
Okay. Just show the ladies and gentlemen of the jury what you believe you saw in the form of a throwing motion. You saw this? Okay. And what you're saying is that what was in that hand, you believe to be a dark object. Would you agree or disagree?
Agree.
And would you agree or disagree when you went to the theater that day, it was not to pay attention to all of the other patrons in that theater, but instead it was to watch the previews and eventually watch the movie, correct?
Correct.
And would you agree or disagree that that is what you were focused on, correct?
Your Honor, I'm going to object to beyond the scope of cross-examination. This is just pointed directly at him.
It's well within the scope.
I'll overrule.
Would you agree that's what your focus when you went to the theaters, to watch the previews and watch the movie, correct?
Correct.
And I believe you told the prosecution on cross-examination that 10 seats away in that theater, you could hear what people were saying to each other. Is that what you're telling us today?
No,
You would agree or disagree the reason that you couldn't hear, you heard some chatter, but the reason you couldn't hear what was being said was because the previews were loud.
correct. And I wasn't paying attention, trying to hear what people were saying.
And you would agree that when, agree or disagree, that when Mr. Oulson first stood up and turned around, you couldn't even hear what he was saying at that moment, correct? When he
No, I
first
wasn't
stood up.
paying attention, yes.
And you couldn't hear it, right? You couldn't tell this jury exactly what he was saying, right?
No,
And the reason you couldn't do that is because the previews were loud, correct?
This is leading.
I will rephrase it, Your Honor.
Sustained.
You would agree or disagree that the reason you couldn't hear that is because the previews were loud.
correct, but I wasn't paying attention,
You weren't paying attention either.
right.
And so you would agree or disagree the only time that you decided to, hey, I'm going to look over there, was because you were being distracted from the previews that you were.
Your Honor, this is leading.
That is leading, sustained.
Would you agree that the only reason you looked to your left and distracted from the previews is because you heard something going on over there, right?
Objection, leading.
That's not.
Sustained.
Now, let's talk a little bit about your husband. He was seated to your right, correct?
Correct,
Okay. And immediately after the flash and the shooting and the gentleman picking up the gun from Mr. Reeves's knee, you decided to get up. Is that correct? Because you felt things were safe at that point.
After the gun is being processed, yes.
Okay. And that's when you went downstairs. Would you agree or disagree?
I went to the platform, yes,
The platform, down below.
down below, bottom of the stairs.
Okay. And you would agree or disagree that after that you went to the exit door?
Correct,
And it was only after, you would agree or disagree that it was only after the exit door that you then joined this group that was standing or sitting there in the theater, correct?
correct,
Individuals that had gone to the theater?
correct,
Okay. And your husband, would you agree or disagree that he was in that group as well?
agreed.
Now, on cross-examination, you told the prosecutor that you were pretty sure about this throwing motion, correct, or disagree?
Correct,
And you told this prosecutor, agree or disagree, that you believe that in that throwing motion, in that hand, the left hand, was a dark object.
correct.
You're pretty sure of that, agree or disagree?
I'm pretty sure.
I have no further questions.
Your Honor, if it's okay, based on recross, I have 5 questions if I could.
Sure. Defense will get the last exam, though.
Thank you. I'm going to be referring to pages 285 and 286. May I approach the witness?
You may. Is there a question?
I'm just going to talk about the lighting and the sound,
Okay.
and going back. Isn't it true that you could see 10 seats away when you were in the theater at the time of the shooting?
Yes,
And isn't it true that although the previews were on, you could hear people 10 seats away at the time of the shooting?
correct.
I don't have any further questions.
Thank you. Anything further from defense?
No, Your Honor.
May this witness be released?
We haven't under subpoena, but she can be released for now.
Okay, you're free to go for now. If you get called back, you'll have to come back.
All right,
Thank you. Who's next?
solemnly swear or affirm the testimony you shall give in this cause is the whole truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Mr. Escobar.
Thank you, Your Honor. Good morning, Sergeant Duff.
Morning, sir.
Would you please state your full name for the record?
David Wayne Duff II.
And Sergeant, would you give the ladies and gentlemen of the jury a little bit of your history concerning your employment? You are
I'm a deputy.
sergeant?
I'm a sergeant with the Pasco County Sheriff's Office. I've been employed at the Pasco County Sheriff's Office since September of 2005. During my time, I've served as a patrol deputy in District 2. I've served as a field training officer, property crimes detective, and a patrol corporal. My current assignment is a patrol sergeant.
Okay. And so you would agree that you are pretty familiar with how to conduct proper investigations, correct?
Yes, sir.
Done it all your career.
Yes, sir.
I'm going to direct your attention to January the 13th of 2014 and ask you if you were called out to the Cobb Theater that day.
I responded out there, yes, sir.
And when you arrived there, you would agree that you went to the superiors over there to get your assignment for that day.
I did.
Is that correct?
Yes, sir.
This was something you've done before, correct? Go to a location, whether it's a theft or a burglary or what have you, and you're going to be interviewing people, right?
Yes, sir.
You're pretty familiar with that process.
Yes, sir.
And you would agree that on that particular day, you were given the assignment to interview witnesses.
Yes, sir.
Is that correct?
Yes, sir.
Okay. Now, in total, you interviewed 6 individuals. Is that correct?
Yes, sir.
No one gave you a list of individuals to interview. You were just supposed to go out there and find them.
Yes, sir.
Is that correct?
Yes, sir.
And your preference certainly that day would have been to go inside Theater 10 to at the very least be able to view the inside of that theater and any evidence that may have been present there in that theater, right?
Yes, sir.
I mean, the reason that's your preference is that if you get a good layout and you find out where the evidence is at, it's going to allow you to pose appropriate questions to witnesses. You would agree with that?
I would agree with that, yes, sir.
And you've certainly gone in your lifetime as a law enforcement officer, you've gone to many crime scenes and viewed crime scenes that gave you a great deal of information that you could later use in your investigation, correct?
Yes, sir.
But you weren't allowed to go into the theater that day, were you?
I don't know if allowed's the right word, sir. I believe I wasn't afforded an opportunity.
You weren't afforded the opportunity.
Yes, sir.
If you had, you would have done it, without a question.
So, yeah, probably yes, sir.
Okay, now, you first started somewhere in the concession area, is that correct, of trying to find witnesses?
Yes, sir.
Okay, and there was a group of individuals there at that concession area, is that correct?
Yes, sir.
At no point in time did you tell any of those individuals there in the concession area not to speak to each other, correct?
I did not, sir.
In fact, when you approached those individuals, they were actually talking to each other, correct?
I don't recall, sir, specifically on that one.
Well, certainly as far back as your initial classes when you became a police officer, the word contamination, witness contamination, has been taught to you, right?
I'm familiar with the term, yes, sir.
Okay. And you would agree with me, the term is that you shouldn't have witnesses to an incident together because you don't want them to contaminate each other with information, right?
In an ideal situation, yes, sir.
Okay. And so there were quite a few police officers there that were sent over to the Cobb Theater, correct?
I don't know the specific numbers, sir. There were several deputies there, yes, sir.
Quite a large group, right?
I don't know how to, there were several deputies there, sir. I don't know whether it would be large or not. I don't know the exact number.
Detectives as well?
Yes, sir.
Upper echelon of brass, correct?
Yes, sir.
In fact, Sheriff Naco was there.
I don't know if the sheriff was there when I was present, sir.
Okay. So, first person that you interviewed was an individual by the name of Mr. Perez. Yeah, you can always let me know if you need to refresh your recollection with your report,
Take a look at my.
and I will ask
Yes.
the court if it's appropriate at the time that you need it, okay?
Okay.
Up to you.
Sergeant, you interviewed a Mr. Perez, correct?
Yes, sir.
Okay. And you didn't even know prior to interviewing Mr. Perez that Mr. Perez had actually filled out a written statement, correct?
Correct.
In fact, when you're interviewing people, that's always the first thing to look at, right?
Depending on the circumstances, not necessarily, sir. I've done interviews with somebody prior to obtaining a written statement.
Why wouldn't you want to read the written statement before you even ask them the first question so that you can get some handle of what this person may have viewed or not viewed?
Do the same thing with a interview, sir.
You would agree you never even looked at that voluntary statement because you didn't even know he had one.
Correct, sir.
So did he come to you without any paperwork at all?
Yes, sir.
And so you didn't ask him, hey, have you filled out a voluntary statement? You never asked him that question?
No, sir, I did not.
You knew that they were passing out voluntary statements. You know what those forms are all like, right?
I know what the forms are. I wasn't aware they had been handed out at that time.
So the individuals that gave you the instructions to interview witnesses there didn't even tell you that?
No, sir, I wasn't given that information.
You never asked Mr. Perez where he was seated in the theater, correct?
No, sir, but referring to my report, Mr. Perez said that the incident occurred 8 to 10 rows behind him.
What does that mean? It all depends upon where Mr. Perez was, right?
Yes, sir.
Was he on the left side? Was he on the right side? Was he in the center? How many people were between him and the incident? Those are all would have been great questions, right?
Yes, sir.
In fact, you would have wanted certainly for you to specifically know the seat that Mr. Perez was sitting in, right?
It would have helped with the interview, yes, sir.
You never asked him about the noise level in that theater, correct, at the time of the incident?
No, sir.
You never asked him about the lighting conditions
No,
as
sir.
well, correct?
No, I did not.
You never even asked him specifically what seats this incident took place at?
I did not.
And you yourself were unfamiliar with this scene?
I I had been in the Cobb Theater prior to this date, sir, both as a patron and as working off-duty
But
details.
not in Theater 10.
I have been in Theater 10 prior to this date, but not at this incident, sir.
And when was the last time you had been to Theater 10 prior to this incident?
Don't have a specific date, sir. I'd have to determine when I worked the detail or if I saw a movie in there.
Okay. You would agree, would you not, that it is extremely important to try to obtain as much detail as humanly possible from witnesses when you're first interviewing them, correct?
Yes, sir.
You're also agree that it's important to ask those witnesses when you're interviewing them whether they have had discussions with other individuals concerning the incident prior to your interview.
Can you repeat that question, sir?
Sure.
I lost you.
You would agree that it is important to ask the witnesses that you're interviewing whether they have spoken to other witnesses about what those witnesses had seen prior to your interview because of the issue of contamination. You want to know whether, is this a purely statement by this person or has it been influenced by someone else? You would agree that's important.
I would agree that is important, yes, sir.
And in fact, not only is it important, you normally do it.
Yes, sir.
But you didn't do it on this investigation.
No, sir.
You would agree that your interview with Mr. Perez was extremely short.
It was brief. I don't know.
Okay, I'll take brief. It was brief.
Yes, sir.
You never even asked Mr. Perez who discharged the firearm.
I did not.
You then interviewed an individual by the name of Mr. Mickley, correct?
Referring to my report,
Anytime you need to,
Okay.
may I
I-
have him refer if he needs
Yes,
to?
he can refer.
I interviewed Ms. Perez after Mr. Perez.
Okay,
and
we'll
then
do them in that order then.
Okay, yeah, I'm just going off
Yeah.
the report.
Would
So-
it be safe to say that all the questions that I asked you about Mr. Perez, you would answer the same as to Mrs. Perez?
Correct, sir.
Okay, save some time. You then interviewed Mr. Mickley, is that correct?
That would be correct, sir.
Okay. And again, you didn't even know if Mr. Mickley had a voluntary statement that he had filled out,
I did not.
because you never asked him.
I did not.
You didn't ask him where the lighting conditions were?
Did not.
Did not ask him what the noise conditions were?
I did not.
You did not ask him who discharged the firearm?
I did not.
You did not know where he was seated?
I did not.
McCullen. Remember that witness, McCullen?
Yes, sir.
Never asked about the lighting conditions.
No, sir.
Never asked about the noise level.
No, sir.
Never asked about where that person was seated.
Did not.
Didn't even know whether that person had a written statement or not.
No, sir, I did not.
Did not ask him who had discharged the firearm.
Did not.
Did not ask him who was shot with the firearm.
Did not, sir.
Stallmeyer, another witness you interviewed?
Yes, sir.
Same questions, same answers you're going to give?
Yes, sir.
Same brevity in the interview?
Yes, sir.
You did realize this was a shooting that resulted in someone's death?
Yes, sir.
You obtained these people from the concession area, correct?
Yes, sir.
You would agree that there was an excess of 20 people there in that concession area?
I don't remember the specific number, sir. There were several people in that area. That's the number that's there then.
And then, were you sent home after these interviews?
We completed our interviews and then we were released from the scene by our supervisor.
And can you tell the ladies and gentlemen of the jury how long you were at that scene conducting these 6 interviews?
I'd have to look at the CAD notes, so I don't have that time frame in front of me.
Less than an hour?
I think an hour, probably at the minimum.
Okay, an hour. No further questions.
Rob?
No questions, Your Honor, thank you.
Thank you. May this witness be released?
Yes, Your Honor.
Thank you, Sergeant. You're free to go.
Thank you, Your Honor.
Who's next?
Your Honor, the defense would call Deputy Christina Demas. Your Honor, can we approach while I'm doing that?
Sure. Deputy, approach, please, to. Go ahead. Oh, she didn't swear. Right, thank you.
Oh, sorry.
Back us.
I'll do it the right way. I'll do it the right way.
Chief, do you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you, Deputy Madam Clerk.
I remember how to do it.
Ms. Demas, you finally get on. You've been
Finally.
waiting quite a long time, haven't you?
Yes.
Would you please state your full name for the record? Let's do it right?
Christina Demas.
And how are you employed?
I'm a canine officer with the Pasco County Sheriff's Office.
Would you please give the ladies and gentlemen of the jury some history concerning your law enforcement career with the Pasco County Sheriff's Office?
I will.
That was your only law enforcement position, is that correct?
Canine?
No, I'm talking about, you were never served as a law enforcement officer anywhere else?
No, this is it.
Okay, so let's take it from the very beginning. Let's give the ladies and gentlemen of the jury some background concerning your law enforcement career.
So I'll make it fast. So it's 23 years. I started as a road deputy, and then I went into vice and narcotics as an undercover detective. After that, I was a bailiff, a corporal in the bailiff sector, which is what she does. And then after that, I went to the road, and I worked under the warrants division as a detective. And after that, I tried out for canine, and I've been a canine officer since then.
What is your rank?
I'm a corporal now.
You're a corporal. So I will address you as Corporal Demas.
As of today, yes, I am
As
a
of
corporal.
Today you became a
Today
corporal?
I am it, yes, I'm back as a corporal, yes.
You're back as a corporal?
Yes, yes.
Okay. I'm going to direct your attention to January the 13th of 2014 and ask you if you recall being asked to go to the Cobb Theater that day.
Yes.
Okay. And would you tell the ladies and gentlemen of the jury who you were with that day when that request was made?
So I was in the warrants division at that time, and I was partnered up with Detective Monty Schuler, who was my partner. We actually rode in the same vehicle together all the time. I was never alone. I was never by myself.
And so once you got the call, you both went together to the Cobb Theater?
That is correct. So we were in the vehicle in Zephyr Hills, and the call came out, and we decided that we would go at that moment in time.
Okay. And when you got there, what area of the complex of the Cobb Theater did you drive to?
So we drove around somebody was actually standing outside directing us exactly where to go, so we responded to the rear of the movie theater, to a door that led into one of the movie theaters itself.
And is it true that while you were there in the rear of the theater, that you were able to see Mr. Reeves coming out of the theater in handcuffs? Is that correct?
That is correct. As I arrived and walked up the sidewalk area towards the door, they were coming out with Mr. Reeves.
And you would agree that Mr. Reeves was cooperative?
He was.
Okay. And so at that point in time, you decided that you were going to proceed into the theater, correct?
That is correct.
And you opened the door to the theater and you looked inside.
I did.
And you would agree that it was pitch black?
So it was black because I was coming in from a very sunny day. So if the lights were on, I wasn't sure at that moment in time. I had to let my eyes adjust.
And you did that?
I did.
You let your eyes adjust and then you actually went in. Is that correct?
I did.
Okay. And when you finally went in, what were the lighting conditions once you got that adjustment made?
I don't remember at that moment in time. I know that eventually the lights were on.
Okay, so at some point in time after you enter the theater, your belief is that the lights went on?
The lights were on at some point in time. I just never paid attention until at that moment.
Okay, and then it was rather light in there?
It was.
Okay, now, light enough certainly for you to be able to do your job, right?
Correct.
Okay, and so the job that you were given initially when you went in was what?
I asked if anybody needed assistance, and they handed me a roll of yellow sheriff's office tape, and I proceeded to tape off the area of which the incident had occurred.
Okay, and you did that alone?
I did.
Okay. Now, while you were there in the theater, you saw a group of people, meaning patrons of the theater, congregating in one section of the theater. Would you agree?
They were on the ramp area on the side of the movie theater.
And did you approach those individuals to make sure that you told them that, hey, don't discuss anything you saw in reference to this incident amongst yourself?
I did not.
Okay. And you would agree that likewise you never overheard anybody doing the same?
That is correct.
Okay. Now, you were in that area for what purposes other than putting the yellow tape?
That was the only reason.
That was the only reason?
That was it.
Nobody gave you any other assignments, correct?
Correct, at that moment.
And you were kind of just waiting for some of the brass to do just that, right?
I was waiting for whoever was in charge at that moment to tell me.
Give you instructions.
Correct.
You're there to help, right?
Correct.
And you would have helped, right?
Correct.
You would have done anything possible
Yes.
to make sure that this investigation was a good one.
Yes.
There was a lot of people in that theater.
There was. Not in the theater, that theater, but out in the, yes, throughout the entire movie theater, yes.
Now, there was quite a few officers. You saw at least 10 police officers,
10
right?
that I can remember.
Okay. And of those 10 that you saw, you never saw a single police officer making any statement to lay people to you can't be talking, guys, let's separate you, right?
I did not at that moment, no.
Did you know that there was, what, 16 theaters in that building?
I actually did not.
And so, you're asked by another officer to hand out some voluntary statement forms, correct?
Correct. So after I had marked off the tape, I went outside into the, I guess it's the open area where the
Concession.
concession stand is. And I asked if anybody needed assistance, and they provided me a stack of written statements and pens and said, there are people sitting in the concession stand at the tables, could you please hand them out to them?
Now, the instructions that you were given were not, however, separate all these people and then have them write their statement.
No, the people were already sitting at the tables. There was 4 or 5 chairs around every circular table, and there was about 4 or 5 tables.
And so you're just handing out these voluntary statement forms to these individuals as they're sitting all in a round table.
I am.
You don't know what the people were talking about, but clearly they were talking.
People were talking, I just didn't hear what they were saying.
That process didn't take a whole lot of time, did it?
It did not.
And when you were finished with that process, you were told, and your partner was told,
Objection, hearsay.
Sustained.
well, let me ask you this question. How long were you there at the Cobb Theater rendering assistance as a law enforcement officer in this investigation?
Between 45 minutes to 1 hour.
And before you left, you wanted to make sure that your services weren't needed, right?
Correct. I walked outside of the front door where the higher-ups were and asked if anybody else needed assistance, and we were told no more assistance was needed.
And in 45 minutes to an hour, you were sent away.
We were sent home.
I don't have any further questions.
You were talking about the house lights coming on. Would you agree with me that the best evidence as to when the house lights came on would be on the video?
Oh, I would have no idea. I've never even seen the video before.
Okay, so what I'm saying is when you say that you think that the house lights came on at a certain point, the video would be the best evidence as to when the house lights came on.
I would assume the video would show it.
Okay. And you indicated that you were there for 45 minutes to an hour, and then you were told that you could leave.
That is correct.
And is that because all of the detectives from the sheriff's office had already come down to do their investigation?
At that moment in time, almost all of the east side and the west side major crimes detective had arrived on scene, and they were already conducting their investigation.
Okay. So in other words, the reason you were told it was okay to leave within 45 minutes to an hour is you weren't needed because all the investigators were there that needed to be there.
Objection calls for speculation.
To the extent she knows, overruled.
You can answer.
Oh, okay. They didn't tell me why, they just told me I was free to leave.
Okay, but you know that all the detectives from the east and west side that would investigate a case like this were at the scene or at least on the way to the scene.
For the most part, yes.
I don't have any further questions.
May this witness be released?
She's under subpoena, Your Honor, but we're going to release her with that caution.
Okay.
We can call her back.
Perfect.
All right.
Thank you.
Thank you. You're free to go. But subject to recall.
Thank you, Corporal.
You're very welcome.
All right. Council, good time for a lunch break? All right, ladies and gentlemen, we're going to take an hour for lunch. Remember my instructions during the recess. Don't do any independent research of any sort. Don't discuss the facts of the case amongst yourselves or with anyone else. And enjoy your lunch and report back to the jury pool room at, yeah? Hang on. hour. Be back at 1 o'clock if you would, please, and remember my instructions. Enjoy your lunch. Thank you.
be seated.
All right, what do we got? More video?
Yes, Your Honor, with these next two witnesses, it'll be short video. It's just going to be segments of some of the videos that have already been introduced.
Okay. All right, I'll have to reposition you guys too, I guess.
Have we approached all the juries that we have?
Yeah.
Jurors in the courtroom, Your Honor.
Thank you.
You may be seated. Jurors are present and accounted for, Your Honor.
Thank you, Deputy. Thank you, ladies and gentlemen, for returning. Were you all able to abide by my instructions during the recess? All right, we're going to get started again. Looks like the board's out again, so state if you want to reposition. I'm going to reposition. Who is your next witness?
The state defense would call on Michelle Simpson.
Thank you so much, Ma'am, for the screen. Turn your face to the clerk and raise your right hand.
Do you solemnly swear or affirm the testimony you shall give in this call will be the truth, the whole truth, and nothing but the truth, so help you God?
Good afternoon, Ms. Simpson.
Hi,
Please state your full name for the record.
Dawn Michelle Simpson.
Ms. Simpson, would you please tell the ladies and gentlemen of the jury how you're employed?
Currently, I'm retired from banking.
Okay, and back in January of 2014, specifically January 13 of 2014, can you tell the jury how you were employed there?
I was in banking at the time. I was a teller supervisor.
Okay, and how long had you been in that particular industry?
A total of 27 years.
Okay. I am going to direct your attention to that day, January the 13th of 2014, and ask you if you had an occasion that afternoon to go and visit the Cobb Theater.
I'm sorry, you...
Did you go to the Cobb Theater
Yes,
that day?
yes.
Okay. I know you're a little nervous, right?
Yeah.
Okay. I want you to relax.
Okay.
Nothing to be nervous about. I'm just going to be asking you some questions, okay? You had an occasion to go on January the 13th to the Cobb Theater.
Yes.
Would you tell the ladies and gentlemen of the jury why it was that you were at the Cobb Theater that afternoon?
Well, I had taken a personal day from work, and my daughter was looking for movie posters for her room, and that's why I went to the theater, just to ask for movie posters.
So you had gone to the movie theater in order to try to retrieve some posters for your daughter's room?
Yes.
Okay, I am going to show you an exhibit that is exhibit number 1, introduced into evidence in this case. And I'm going to ask you to step down if the court will permit me.
Yes.
Yes.
Let me move to.
You're probably good right there. We'll be able to see on this big screen. I don't think you need to get any closer right now. I'm going to show you a portion of exhibit number 1 that's been introduced into evidence. Go ahead. Matt. You stop it there, right there. Ms. Simpson, do you recognize the individual that is there at the counter of the Cobb Theater?
Myself, and I believe that's the manager.
This is you here?
Yes.
Okay, and this is the manager that you had approached that afternoon?
Yes.
Okay. Continue, Matt. Stop it right there, Matt. Do you recognize the individual that just walked up to the counter?
Mr. Reeves?
And do you recognize Mr. Reeves here in the courtroom? Can you please point out to Mr. Reeves here in the courtroom? And can you tell us what he's wearing?
A gray jacket and burgundy tie.
Okay. Your Honor, let the record reflect that she has identified Mr. Reeves. And so, when Mr. Reeves first walked up to the counter, did you notice anything about him that would have given you an indication that he was angry or mad or anything of that sort?
No.
And so you continue to talk to the manager concerning your request?
Yes.
Matt, would you continue? Okay, stop there, Matt. Now, while you were speaking to the manager there, could you tell the ladies and gentlemen of the jury of what you noticed of Mr. Reeves at that point in time?
Well, I just noticed that he was off to my left. He was not behind me, he was to the side of me, a few feet away from me.
Did he interrupt in any way, shape, or form what you were discussing with the management?
No.
Did he appear to be patient and courteous in this whole process?
Yes.
Go ahead, Matt. Can we stop there for a second? Now, you moved over to one side of the counter, is that correct?
Mm-hmm.
And could you tell the ladies and gentlemen of the jury what you were doing when you moved over to one side of the counter?
I was going to make out a list of the posters that my daughter was looking for to leave with the manager.
Okay. And even though you were doing that, were you in earshot of the conversation that Mr. Reeves was having with management there?
Yes.
And were you able to witness Mr. Reeves' disposition as he was having that conversation there with the manager?
Yes.
Okay. And could you tell the ladies and gentlemen of the jury whether you noticed anything that gave you any indication that Mr. Reeves was upset or mad or anything of that sort?
I didn't observe that, no.
And did you observe him being courteous and pleasant while he was discussing the matter with the management?
What I observed, yes.
Okay. Go ahead, Matt. Stop there. In that segment of the video, it appears you look over towards Mr. Reeves, correct? To make your observations of what he was doing and how he was doing it? Is that correct?
Objection,
Sustained.
Is it true or not that you looked over there to make your observations? Is it true or not?
Yes.
It is. Go ahead. Stop there, man. It appears that you continued after Mr. Reeves left the counter. Is it true that you continued talking to management?
I don't recall if I said anything else to management.
Did you get the posters that you wanted?
No.
Okay,
They
can you
didn't
tell the
have
ladies and gentlemen of the jury why not?
They didn't have them.
Okay. And so what did you do at that point in time?
I decided to just leave, and I was gonna come back at another time and see if they had more posters.
You may take your seat. Matt, you can, Now, you left that day, and where did you go?
I went home.
Okay, and on your way home, did you see any law enforcement cruisers?
Yes.
Okay, and when you got home, tell the ladies and gentlemen of the jury what you did.
When I got home, I turned on the TV, which is not abnormal. I do that when I get home. And breaking news was just going off the television. And I had seen enough to know what was going on, that I was just there. So I got on my computer.
To find out what was going on in the Cobb
Yeah.
Theater? Okay. And did you obviously realize that you were just there?
Yes.
Okay. And so what did you do? Did you call law enforcement that day from your home?
I did, but I had called my mom first.
Okay. And what, without telling me what your mom told you, did whatever conversation you had with your mom result in you calling law enforcement?
Yes.
Okay. And did law enforcement contact you back?
Not that day, no.
Okay. Did they contact you back, period?
A detective did,
Okay.
Yes.
And was that in person or was that telephonically?
telephonically.
Okay. And so a detective contacts you telephonically, and was that, did you have an interview with that detective?
Just over the phone.
Okay. And did you tell the detective what you told the ladies and gentlemen of the jury here today?
Yes.
Was that interview between yourself and the detective quite short?
Yes, it was short.
I have no further questions.
Thank you. Mr. Escobar or Mr. Funderburg, could you turn that off when it's not in use?
It has to reboot, that's part of the problem, and can you turn the screen?
Okay, just the
Okay.
screen, thank you. Okay, Cross?
Yes, ma'am. May it please the court, counsel? Ladies and gentlemen, good afternoon. Mrs. Simpson, good afternoon, ma'am. Mrs. Simpson, you would agree with me that when you were standing at the service desk and you indicated you saw Mr. Reeves walk up, correct?
Yes.
Did he exhibit any signs of urgency?
No.
And what I mean by that, you were standing there, did he tell Mr. Peck, excuse me, I'm sorry for interrupting, but I have an urgent matter that I need to discuss with you?
He didn't say that, no.
Okay.
Those words.
In fact, did you ever hear Mr. Reeves indicate to Mr. Peck that there was an individual in the theater cursing at him?
I didn't hear that.
Did you hear him say that he had been threatened?
I didn't hear that either.
Did you hear him say that there's imminent violence, that he needed him to come into the theater right away?
No.
He didn't say any of those things, did he?
No. Not in those words.
In fact, he never told Mr. Peck that, quote unquote, he was scared shitless.
I didn't hear those words, no.
Okay. May I have a moment, Judge?
You may.
I have no further questions, Your Honor.
Just
Ready to roll? Yeah, go ahead.
Ms. Simpson, was Mr. Reeves speaking softly, normally, there at the counter?
A normal voice that I heard, no.
He certainly wasn't speaking like this.
No.
I have no questions.
May this witness be released?
Yes, Judge.
Yes, Your Honor.
All right, thank you, ma'am, you're free to go. Who's next?
Your Honor, the defense would call Thomas Peck.
Okay. He's not talking, it's okay.
Okay.
I have to get my shoes resoled.
Okay.
You solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, truth to help you God?
I do.
I feel like this was a rerun, huh? Good afternoon, Mr. Peck.
Good afternoon.
Mr. Peck, would you please state your full name for the record?
Thomas James Peck, Jr.
In an effort to get to know you a little better, would you tell us about your educational background?
I attended the Culinary Institute of America, graduated as a chef, and it's basic.
Okay. In 2013, were you employed at the Cobb Theater?
Yes, I was.
And specifically on January the 13th of 2014, could you tell the ladies and gentlemen of the jury what position you held there at the Cobb Theater?
I was the general manager.
Okay. And would you tell the ladies and gentlemen of the jury what that means as a general manager? How many people do you have under you and in what capacities?
I have about 9 managers under me and about 80 or so employees
Okay. And that Cobb Theater was located where?
in Wesley Chapel.
Okay. Now, there at that particular theater, you have different offices, is that correct?
That's correct.
Okay. And you also have a section that's called the Cena Bistro, is that correct?
Yes.
Okay. And was the Cena Bistro opened on the time slot of this particular incident?
No, it was not.
And it's my understanding that in an effort to get into the Cena Bistro area, do you have to go through an elevator?
Yes, elevator or stairs.
Okay. And that is a separate location that is only for Cena Bistro patrons?
Correct.
So in other words, if you're in the general seating, you just can't go up there just because you want to?
Correct.
Okay. It's only for those guests that have paid for that particular service?
Yes.
And at this time, you're saying, the day of the time of this incident, it was non-operational?
It was not operational, no.
Okay. Now, tell me a little bit about the Cena Bistro. How many theaters do you all have there?
6.
Okay. And how many rooms would you say you have in the entire complex?
16.
16. Okay.
Auditoriums?
Yes.
Yes. Okay.
16, right?
Yes.
Okay. Now, in addition to that, you have some offices that, your office, is that correct?
Correct.
And where is that office located?
It would be, as you're coming into the building, be to the left-hand side, down by past theaters 1 through 9.
Okay. And do you have some offices upstairs as well?
Yes.
Again, what offices are upstairs?
The manager's office, projection IT tech office, server room, and yeah, that's it for offices up there.
And at the time of this particular incident, you had a surveillance system in place in various parts of the complex, is that correct?
That's correct.
And one of those particular areas was Theater 10, is that correct?
That's correct.
And did those cameras capture the entire general population area of Theater 10?
No,
It covered just a very small, limited portion, is that correct?
that is correct.
Those cameras were positioned where in that theater?
They were positioned in the upstairs balcony for the Cinebistro side.
Okay, is that pretty high up in the wall, like 30, 35 feet up?
I would be guessing, but yes, I mean, it could be
Okay.
there.
Okay. Now, you had some capabilities of being able to see that particular surveillance system from various parts of that theater, is that correct?
Yes,
And would you tell the ladies and gentlemen of the jury all of the different areas that you could have actually accessed that surveillance system to be able to view it?
one access area would be the general manager's office.
And where would that be at?
That'd be down by theaters 1 through 9, down that side downstairs.
Okay,
And then one would be the IT projection booth,
okay.
or office.
And that IT projection office was located where?
Upstairs, past the Cinebistro theaters, to the right, I would assume.
Okay. And what is housed in that IT room?
In that particular room, there's DVRs, the tech's PC, and chair office equipment and stuff like that, and other wiring and stuff for the projectors.
So all of the DVRs for that surveillance system would be up there in that IT room?
Yes,
Okay. And you've indicated, I think, that you could see that surveillance from that room as well?
yes, you can.
Okay. Do you all use that capability, the capability of being able to, either from your office or from the IT room, to view surveillance that is taking place throughout the complex?
Yes.
And would you tell the ladies and gentlemen of the jury some of the reasons that you go on to the surveillance system to see what's going on?
Yes, we would look at it for instance, if somebody had their phone out or something for recording, if somebody was, if there was a situation we need to assess, if somebody was taking something from our concession stand, monitoring our POS systems, point-of-sale systems for our own staff to make sure monies are being counted right and also change are being counted right. And just if we have any other incidents, we have to look up, like, you know, again, somebody in a theater that doesn't belong in a theater or something along that line.
Okay, and so did you use that capability of your surveillance system to view often?
Yes, yes,
Okay, and so you were familiar with the operation of it, correct?
yes, yeah, the basic viewing operation, yes.
Your other managers were also knowledgeable about operating the system?
Yeah, somewhat.
Okay, and even some of your non-managers were experienced in viewing the system, correct?
Yes.
Now, in viewing that system, are you able to actually see the time stamps of when things are happening?
Yes, you can.
Okay. And so you're able to actually look at the surveillance system and then know when those things that you're viewing are taking place?
Based on the timestamps, knowing that timestamp, yes.
Okay. Now, I would imagine in the past, when you've had instances, and correct me if I'm wrong or right, if you needed to have a police officer view video for something that may have occurred in the theater, you've provided that access to law enforcement, correct?
Yes, we wouldn't refuse it, yes. I mean, yes.
That's, you, at times, at that theater, have law enforcement present there, do you not?
Yes, we did.
Would you tell the ladies and gentlemen of the jury when you have law enforcement present and when you don't?
At that time, we had law enforcement present on weekends, like Fridays, Saturdays, and Sundays.
So just Fridays, Saturdays, and Sundays?
That's correct.
Okay. And certainly they would have had access, like you would have access to that room upstairs, the IT room, as well as your office, if they needed to view video?
Yes, they requested it, absolutely.
What about corporate, Cobb Theater corporate? Did they have access in a way to likewise view remotely what was taking place at each of the camera areas of the Cobb Theater?
Yes, they could dial in.
And what does that mean, just so that the ladies and gentlemen of the jury are clear on what that means, dial in?
They could dial in remotely through like computer-to-computer talking. I couldn't tell you the technical terms, but they can dial in where they can pull up the computer, take the computer per se, and we would recognize that because the background screen would turn black from blue, and we'd know they were watching it. So.
Okay. And would corporate do that from time to time?
Yes, and from time to time they would, yes.
But not real often?
No.
Okay, so let's talk a little bit about, that particular day, and I want to talk to you a little bit about lighting conditions there at the theater, if I can.
Okay.
There's a segment, and correct me if I'm wrong, there's a segment where commercials are played in the theaters, is that correct?
Yes, that was.
Okay, and what are those called?
30 minutes prior to trailers, we have NCM, which was National Cinema Media, and over time it's changed names, but it's NCM at the time, and they basically just show advertisements. Local companies can buy advertisement space and just show commercials, and once in a while you have a little quick movie push put in there too. But
Now, during that segment of the experience, what are the lighting, what's the setting of the lightings during that experience, the commercial experience?
we would call that level 1 full house lighting.
Level 1 full house lighting?
Yeah.
Okay, and then after these commercials are concluded, what comes on next?
You'll get a couple PSAs, public service announcements, and then it'll go into the trailers.
Okay, so let's talk about some of those public announcements. Is there an announcement that comes on that is telling the audience to turn off their phones and put their phones away?
Yes, there's one about being courteous, having your phone off.
And why is it that the Cobb Theater has that particular announcement go out prior to the previews?
Just to be courteous to the guests, to other guests when they're watching movies. There's nobody on their phones and stuff like that.
What is the goal of the Cobb Theater when they're inviting individuals to come and see movies? What's their goal?
To provide a great guest service experience for all.
Okay. And so that announcement comes on. Is it just visual, or is it visual and audio as well?
It's visual and audio.
Okay. Meaning that you're seeing illustrations on the screen that clearly tell someone, turn off your phone, and there's also a voice telling someone, turn off your phone.
Yes.
Okay. Now, do you have some sort of monitoring process that you all use to make sure that that theater experience is preserved for the paying customer?
Outside of, we would have hopefully our ushers doing proper theater checks, which they'd walk up and down the aisles, make sure everybody was, in their seats doing what they're supposed to be doing.
Is that what you have trained your ushers to do in looking for individuals that were not abiding by that particular rule at the Cobb Theater?
Yes, at the right timing, yes.
Okay. And what would happen if an usher were to see someone violating that rule by using their phone in the theater?
Depending on the timing of it, they would be asked to please refrain from using your phone.
And if that individual, for whatever reason, told that usher, I'm not going to do it, what instructions did you give your usher as to what they were to do under those circumstances?
They would notify a manager to ascertain the situation.
So they were trained to notify a manager to handle that situation from that point forward?
Correct.
Okay. And you would be a manager?
Yes.
That they would come to, is that
Yes,
correct?
that's correct.
And you had other managers that they would come to as well?
Yes.
Were you trained by Cobb Theater as to how to handle that situation once that happened, meaning an usher came to you and said, hey, there's some guy, I approached him, he doesn't want to turn his phone off. Were you trained by Cobb Theater on how to handle that matter?
Yes.
And so what would be the next step? You've been told now that a patron has refused to turn off their phone. What is the next step in processing in order to preserve the paying customer's experience?
We would go in there and again ask the guest, whether it be manager and the usher or just the manager, would go in there and ask the guest to please turn off their phone.
Okay, and what if the patron said, I'm not going to do it?
Again, depending on the timing of what was going on the screen, I mean, we would then ask the guest to please step outside and we would discuss it with them.
Okay, and what would happen if, in fact, the patron didn't want to do that?
Well, then we'd have to accelerate it upward to law enforcement.
Okay, and so if you were not able to accomplish what you were trained to accomplish in that circumstance, you would then contact law enforcement?
Correct.
Okay. How long is that announcement telling people to turn off their phones?
I would say 20, 30 seconds, somewhere around there.
Okay, so let's talk a little bit about where you were on January the 13th of 2014, just prior to this incident taking place.
Okay.
And let me ask you one more question about phones. Having the phone out and texting on that phone, is that still a violation of your policy?
Yeah, at certain times when the lighting's at a certain level, it would be, yes.
Meaning previews?
Yes, we would look at it.
Now, where were you immediately prior to this incident taking place?
I was at the guest service desk.
Okay, Matt? Your Honor, I'm going to be asking Mr. Peck if he could step down. Is that possible?
Judge, may I move, please?
Mr. Peck, if you could just stand here and not in front of any of the jurors, but maybe right here so that you can see the screen. I'm going to show you what's been entered into exhibit as exhibit number 1, into evidence as exhibit number 1. And I'm going to play a segment of that and tell me if you recognize what's being shown on this exhibit. Go ahead, man. Stop. Now, Mr. Peck, do you recognize the individual that is seated here?
Yes, that's myself.
That is you?
Yes.
Okay. And do you recognize this young lady here that is standing there talking to you?
Yes.
Okay, and tell me what was taking place at that time as you appeared to be having a conversation. Is that correct?
Yes.
And what was that conversation about?
I believe it was about, she was asking for movie posters.
This young lady was asking for movie posters?
Yes.
And what instructions were you giving her in an effort to accommodate her request?
To write down what movie posters she was interested in and phone number, contact information, stuff like that.
And you were going to try to get those posters for her?
We would try.
Okay. Go ahead, Matt. Okay, stop right there. Now, Mr. Peck, you recognize this individual here that approached your desk here and is situated in the video as you can see him?
Yes.
And do you know who that is?
Yes, that's Mr. Reeves.
Okay, and do you see Mr. Reeves here in court?
Yes, I do.
And would you please point out to Mr. Reeves as to what he is wearing?
He's seated right there, gray jacket, red tie, white shirt.
Okay. Now, go ahead, Matt. Stop. Now, did you notice anything while you were having this conversation with this young lady that caused you to be interrupted at all by Mr. Reeves?
Not that I recall, no.
Okay. Did it appear that he was waiting there patiently while you were finishing your conversation?
By viewing it, yes.
Okay. Go ahead. Okay, stop. Now, it appears that now you're having a conversation with Mr. Reeves. Is that correct?
Yes.
Okay. At any point during that conversation, did you get any feeling that he was angry, upset, mad, anything of that sort in the conversation you were having?
Not that I recall.
Go ahead, ma'am. Okay, stop that. Now, during that entire conversation, did you have any exchange with Mr. Reeves where you believed again that Mr. Reeves was mad, frustrated, angry, or anything of that sort?
Not that I recall.
Did he appear to be polite in the conversation that you had with him?
I don't recall the conversation, but, I mean, looking at the appearance, yes, it appears fine.
If he had been mad, upset, or what have you, is that something you think you would remember?
I would think so.
Okay. And so it appears that he looked back at one point in time in the conversation. Is there a sign that says Theater 10 right behind where he was positioned?
Yeah, it would be up right outside the auditorium, so.
And it's right number 10,
Mhm.
that's right under the door
Yes.
as you go in? Okay. You may take your seat. You can-
Go ahead, Mr. Oulson.
Thank you, Your Honor. Now, Mr. Peck, shortly after that conversation that you were having with Mr. Reeves, tell the ladies and gentlemen of the jury what takes place next.
Next thing I can recall was that somebody came around out of the theater and said, "You shot him, call 911.
Okay. And so you initially tried to call 911?
Yeah, I tried calling from the landline and was not successful at that time.
And what was wrong with the landline at that point in time that it was not successful?
It just kept ringing, and plus also I hung up as it kept ringing because I figured I need to be more mobile.
Okay, and so what did you do in an effort to be more mobile?
I took my cell phone and started walking towards the auditorium and called 911.
Okay. Did you in fact reach 911?
Yes, I did.
Okay. And after speaking to 911, did you stay there in the front lobby area, or did you go into Theater 10?
I was moving towards Theater 10. Guests were coming out, and I was talking with guests as they were coming out, trying to keep them calm as I was making my way towards the theater.
Okay, and please tell the ladies and gentlemen of the jury what you were trying to do in order to keep these guests calm.
I'm just trying to tell them, relax, please calm down, just giving reassurances, just having some of my staff members help them, have them sit down, have them calm down if they can, as I headed towards the
Why
auditorium.
were you doing that? Did it appear to you that they were emotional and frantic?
Objection, leading.
Why is it that you were doing this?
There was just, it was a lot going on, a lot of commotion, a lot of anxiety, and a lot of people anxious and emotional about it, I would guess, yes.
Okay. And so, what are you doing physically in trying to calm that down?
Nothing physically except for just like whether it's, kind of guiding them to a chair or talking to them, instructing staff members to hand them a drink of water or something, whatever I could as I make my way towards the auditorium.
Okay. And so you made your way to the auditorium with your phone in your hand?
Yes.
Is that correct?
Yes, that is correct.
And tell the ladies and gentlemen of the jury exactly where you went once you made that turn.
I went into the auditorium 10, walking down the right-hand side of the hallway, and took a left around the, I guess it's the wall, and started walking up the stairs
Okay. And what was your purpose in doing that?
to let 911 know what was going on at that time and to see what was going on as well.
Were you talking to 911 at the time?
Yes, I was.
Okay, and so you get up those stairs and tell me what you're doing once you reach the top of those stairs.
First, I noticed Mr. Oulson on the floor, unfortunately, and then I also noticed somebody, Mr. Reeves at the time, now I know who he is, sitting in a chair with somebody, I don't know if he was to his right as I'm facing him, maybe to his left, with a hand on his shoulder.
Okay. At that point in time, when you noticed Mr. Reeves in that back area, did you notice where his hands were?
I think at one point he was wiping his brow, and his one hand was down by his side, but he was wiping his brow, his face.
Okay, you don't know which hand that was?
No, I do not.
In your conversations with the operator, did you indicate to the operator that, and correct me if I'm wrong here, something to the effect that the assailant was still there?
Yeah, I said something like that. They said, because they were asking about the, where the weapon was, and I said, the weapon's been detained and the assailant is still there.
Okay, did you get a response from that statement?
Something to the effect of, don't call me that, or something along that line.
What about, I'm not the bad guy?
Yeah, maybe not, yeah, I would say.
I object. It's 403. It's not,
It's a state statement. Now, Mr. Peck, following that conversation with 911, did you contact corporate?
Yes, I did.
Okay, and tell the ladies and gentlemen of the jury how it was that you contacted corporate there from your building.
On my cell phone.
Okay, and did you advise corporate of what was taking place?
Yes, I did.
Okay. Now, obviously you were aware that there was a surveillance system that was in place, correct?
That's correct.
And did you, at that moment, go and view the surveillance system yourself?
No, I did not.
Do you know if corporate was actually utilizing the remote capabilities to view the surveillance system?
I heard they were, yes.
Well, did you not only hear that they were, did you see that they were?
I did not witness that, no.
Okay. So, let's talk about that. You now have a lot of police officers that are arriving at the Cobb Theater, correct?
Yes.
And there was quite a few, were there not?
Yes, there were.
And did you, at any point in time thereafter, as they were there in the Cobb Theater, did you go and meet with one of them and say, you know, come with me to...
Objection, leading.
I will change that, Your Honor. Do you agree or disagree? Whether you went and summoned some police officer to go view the video?
I did not.
Okay. Why?
Just a lot going on that day. We were running around doing a lot of different things, talking to people on corporate phone, ascertaining the situation, going back and forth, helping guests, helping staff, keeping staff calm.
Well, but if you're going to view those surveillance films for something that is much less serious, right? Someone, stealing something from somewhere in the theater, or, someone, violating some rule of bringing in their own popcorn or what have you, why not do it for this?
There wasn't the timing to do it at that time. I was too busy doing other things at the time, so I wasn't going to sit down and watch a video.
Would you agree or disagree with me that corporate did not want you to turn over those videos to law enforcement?
They didn't want me to be involved in it, no.
And do you agree with me or disagree that they made that clear?
I believe when I spoke to Jeremy Wellman, I believe that he said that let Seth Gordon deal with it and others deal with it.
Now, that day there at the Cobb Theater, that matinee period, how many employees were there at Cobb?
Being a Monday, probably, I would guess at this point, 12, 15, maybe,
12
tops.
to 15 employees.
Yeah, yes.
Now, you became aware, did you not, that, agree with me or disagree, that Cobb Theater sent John Sillis over to that theater
Yes,
late that night
yes,
in order to come and retrieve the hard drives from the surveillance system, correct?
that's correct.
And you agree with me or disagree that the instructions were that those hard drives...
Objection, hearsay.
Rephrase. Sustain.
Would you agree or disagree that Cobb Theater gave the instructions to fly those hard drives that very night?
Rephrase. Sustained.
Let me ask you a question. What did John Sillis do that night?
I wasn't there, but he came and removed the hard drives.
Objection beyond his scope of his knowledge. Just passing on hearsay.
He said I wasn't there.
Sustained.
Now, was Cobb opened the following day?
No, we weren't.
Was Cobb opened the day after?
I think we were. I think we reopened 2 days or 3 days later.
2 or 3 days later.
Correct.
And so, sometime thereafter, did you go on vacation?
Yes, in March.
In March. And did you come back from vacation?
Yes, I did.
When you came back from vacation, was the same surveillance system in place?
Same system, new DVRs.
New DVRs?
Correct.
New hard drives?
Yes.
Would you tell, ladies and gentlemen of the jury, where the hard drives that were in that surveillance system were the day following this incident?
No, I'm going to object. There's no predicate like that he has any personal knowledge of that.
To the extent he knows, overruled.
Where were those hard drives?
From what Fred Myers told me, they were shipped to...
Approach. Go ahead, Mr. Escobar.
Thank you, Your Honor. Did you have some conversations with law enforcement that very afternoon?
Yes.
And do you have any recollection of those conversations?
No, I do not.
Are you telling this jury that if an officer had approached you to see those videos, what would you have done?
I would have taken them to see the videos.
You would have taken them to see the video?
Yes.
Even though management didn't want you to do that?
Well, you asked me if they asked me to see the videos. If corporate gave me directions not to see the videos, then I would not take them, obviously.
So you would have to go corporate?
I would call corporate and say, hey, so-and-so may want to see a video.
Do you know if any other employee or manager had a conversation with law enforcement there? That day, that afternoon?
My projectionist, I think, would have. Our IT person might have, Eric Andrew.
Objections is all speculation.
Well, let me ask you this question. If those conversations had taken place, is there a procedure in place for them to call corporate as well?
Yes.
Did any police officer interview you concerning the contact that you had with Mr. Reeves there at the front counter?
Not that I recall.
Had a police officer asked you those questions, would you have answered them as you've answered them today here in front of the jury?
Yes.
I have no further questions.
Thank you. Ross?
Yes, sir. May it please the court, counsel. Mr. Peck, good afternoon.
Good afternoon.
Mr. Peck, you would agree with me, would you not, that the phone rule is relaxed during previews
Yes.
and it's strictly enforced during the movie?
Our
correct?
focus is on the movie feature.
Okay. And you would agree with me that that rule is on a case-by-case basis,
That's correct.
correct? Now, as far as theater goes, Theater 10, there's only one way into that theater, correct?
Correct. Yes, one door.
All right.
Or two doors, but one entrance, yes.
And is it fair to say that the goal of Cobb, or the goal of Cobb back then, was you wanted the patrons to have an Oscar moment?
Oscar-winning moments, yes, sir.
Okay. You indicated on that date, you saw yourself in the video, you were at the service desk,
That's correct.
correct?
Yes.
What were you doing at the service desk?
On a Monday, probably looking at our P&Ls, looking at different things on the computer, talking to guests as they come up, talking to different people as they approach.
Okay. You would agree with me, would you not, though? You weren't busy.
I mean, we weren't that busy, no, at that
Right.
moment, no.
And in fact, during that time period, you were having trouble with the sink upstairs, were you not?
I believe so, yeah,
Okay.
yes.
And then a young lady, Miss Simpson, came in, correct?
Correct.
She was asking you for posters, right?
Yes,
And we even see you grab a pad and a pen, and I think you indicated, okay, write them down, the ones that you're looking for, correct?
correct.
As you're doing so, you would agree with me that Mr. Reeves comes up,
Yes,
right? And you would agree with me also that he never exhibited any type of urgency, correct?
yes,
He never said, excuse me, ma'am, but I need to talk to the general manager or the manager right away. I've got an urgent matter, right?
yes,
And in fact, when he spoke to you, he never used the F word, did he, Mr. Reeves?
not that I recall.
Okay, if he had, you would have remembered it, right?
I would think so, yes.
That's something you would definitely remember, correct?
I would think so, yes.
All right? I mean, it's not every day that there's a shooting in your movie theater, correct?
It's correct.
And in fact, you indicated to Mr. Escobar, you do not recall a lot of the events, correct?
Correct.
You would agree with me, Mr. Peck, that you were sued personally as a result of this?
Yes,
May I have a moment, Judge?
You may.
Your Honor, I don't have any further questions, Mr. Peck.
Thank you. Redirect.
Mr. Peck, you agree or disagree that the announcement that comes on before the previews to turn your cell phones off and put them away apply to both the previews and the movie?
Yes,
And you would agree with me, would you not, agree or disagree, that you enforce that rule for previews and movies, correct?
yes, we try to.
You agree with me or disagree that you don't tell the patrons as they're coming in, hey, listen, phone use in the previews are okay.
That's correct.
So are you telling this jury then that it is okay?
Objection, leading.
Do you agree or disagree?
Sustain.
Do you agree or disagree that based upon the rules that were in place on January the 13th of 2014, that the minute that announcement comes on, it was telling your patrons to turn off their phones?
Yes, I would agree. It's telling them to turn off the phones.
And your ushers monitor that period of time after the announcement is made to make sure that the theater experience is preserved, correct?
Yes,
So when you said on cross-examination that that announcement did not pertain, was not enforced during the previews, that was not correct.
no, what I said is we're a little more relaxed during the previews.
Well, did you tell your patrons when they first came into the theater that your rules are more relaxed during the previews?
No.
I have no further questions.
May this witness be released?
Yes, Judge.
Thank you, Mr. Peck. You're free to go.
Thank you.
Yeah. All right, let's take a 10-minute recess. Ladies and gentlemen, remember my instructions during the break, and you're going to head back to the jury pool room. Just be ready in 10 minutes. Thank you. Yes? Thank you, Deputy. Thank you, ladies and gentlemen. Were you all able to abide by my instructions during the recess? All right. Then we'll begin. Mr. Michaels?
Your Honor, the defense calls Vernard, Dr. Vernard Adams.
I'm so sorry. I'm so sorry. I was trying to, let's go this way, sir, if you don't mind. Right here, raise your right hand. You're gonna face the clerk. She's gonna take that.
Do you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Right here, sir. Thank you.
Go ahead, Mr. Michaels.
Thank you, Judge. Please state your name.
My name is Vernard Adams.
Could you spell your first name for the court reporter, please?
That's V-E-R-N-A-R-D.
And what is your profession?
I'm a consulting forensic pathologist.
Okay, so you're a medical doctor.
I am.
Let's talk a little bit about your education. Before I go over some of your background and qualifications, and Your Honor, I've shown this to the state. They don't have an objection. This is the defense exhibit marked M. I'm going to approach the witness and leave it there with the court's permission.
You may.
We're not offering to enter this into evidence.
Right. Okay.
Recognize that?
I do.
Okay, what is that?
My curriculum vitae.
Okay, will that help you go over some of the details of your long career?
If you get into enough detail, yes.
Okay, let's start out with your bachelor's degree. Where is that from?
The University of Maine at Orono,
And what year did you graduate?
1975.
And did you have were you recognized with any distinctions or honors that speak to your academic excellence?
At this time, the state will stipulate that he's qualified to testify in the areas that I know wish to testify in, and he may render his opinion.
And I appreciate that. We're still going to go into his background.
Okay, thank you, thank you.
Any honors?
Yeah, Phi Beta Kappa, Phi Kappa Phi, and the degree was with highest distinction and high honors. I did have to refer to that.
Okay. Well, it's 75. So let's go to your medical doctor. Where did you go to medical school?
Tufts,
And where's that?
Boston,
When did you graduate?
1979.
Now, let's talk about any sort of residency or fellowship training you did.
Okay. Out of medical school, my first year of residency training was in anatomic pathology at the New England Medical Center, which is now known as the Tufts Medical Center.
What's anatomic pathology?
Anatomic pathology encompasses the work that pathologists do in a hospital, including mostly reading surgical biopsies under the microscope, doing pap smear readings, and the occasional autopsy in a hospital.
Excuse me, Your Honor, I understand, but there's a lot of artifacts in the middle of the courtroom, close to the side. I'm just trying to figure out where I can move so I can see the witness. So may I just figure that out?
Can this be moved back anywhere until he's ready to use it?
It's actually, it's just chilling in here. I'm trying to just move around and I've been on the approach on Mr. Escobar either.
Is that any better?
He's got clear view.
You're from there.
Your Honor, the jurors are asking, can we turn off the white screen until we need it?
Oh, I thought it was off already.
No.
Turn it off, please, thank you. All right, are we good? Thank you.
No, until we need you. Is that a little better, Mr. Martin?
I appreciate the accommodation. Thank you.
Okay, let's talk about board certifications.
We were in the middle of residency training and didn't finish that. Did you want to skip the rest of it or go on to?
I
boards?
didn't. I was interrupted and lost my train of questioning. Let's talk about residency and training.
Okay. After that year at the New England Medical Center, I went to the Mayo Clinic in Rochester, Minnesota, and did 2 years of anatomic pathology and 2 years of clinical pathology.
Okay. And after that?
After that, I went to Miami and did a year of forensic pathology at the Dade County Medical Examiner Office. It was known as Dade County back then. I still call it that.
Now it's called Miami-Dade County.
Yes.
What about any board certifications? That's where we were going.
I'm board certified in anatomic and clinical pathology and in forensic pathology.
Now let's talk about some of your positions that you've held in terms of employment, professorships, employment as a pathologist or medical doctor.
Okay. After I finished training, I took a position as a medical examiner in the Commonwealth of Massachusetts, working principally in Worcester, Massachusetts, based at the University of Massachusetts Medical School, and occasionally in Boston. After 2 years of that, I went to Suffolk County, Long Island, which is the eastern 2/3 or 3/4 of Long Island, New York, and was a deputy medical examiner there for, as I recall, just under 2 years. I worked for Dr. Charles Hirsch. Dr. Hirsch was recruited to replace the chief medical examiner in New York City, and I went with him to New York City and worked in the Manhattan office for just over 2 years. And at that time, I had a faculty appointment at New York University, which was an affiliate of the medical examiner office. After that, I took a position as chief medical examiner in Hillsborough County, Florida, which, as you all know, is Tampa is the county seat, with a faculty appointment at the University of South Florida. And I stayed there for 21 years, and then went to West Virginia University, where I was a professor of pathology and director of the autopsy service for 3 years, and trained the residents in autopsy pathology, as well as the pathology assistant students. WVU ran a school for pathology assistant students. I left that position after 3 years in 2015 and have been doing consulting for litigation attorneys since that time.
And are you still licensed to practice medicine in the state of Florida?
I am.
Okay. Let's talk about publishing. Have you been published?
Yes.
In what form?
Articles in medical journals, several book chapters, and I did one professional book which was designed to assist pathology trainees, fellows in forensic pathology, and how to write competent and cogent autopsy reports.
Okay, let's talk about some of the peer-reviewed medical publications, okay? Peer-reviewed means what?
Peer-reviewed means that the article was looked at by a board of review editors who then criticize, make suggestions for improvement before it's ever published, or they can reject the article.
And do you have your CV in front of you? Could you turn to page 6, please?
Yes.
Let's just talk about a couple of those. Number 1, what is the title of that?
Number 1 is called Trauma of the Pericardial Sac and Heart, an Autopsy Series. It's published in a journal called Academic Forensic Pathology, which was at that time completely online. That was in 2015. And I wrote that with Sarah Zidowich, or Zidowich, depending on how you like to pronounce the name of that type. And she was one of the forensic pathologists that I trained in Tampa. We had a training program in affiliation with the University of South Florida. She went on to work at the Orlando office.
Let's look at number 8.
Number 8, I wrote that with Claude Guidi, who is a radiologist based at Tampa General Hospital, and it's called Venous Air Embolism and Homicidal Blunt Impact Trauma, Case Reports, published in the American Journal of Forensic Pathology in 2001. Venous air embolism occurs when air gets drawn into veins and then collects in the right side of the heart and blocks the circulation. It's analogous to a pulmonary thromboembolism, which probably most of you have heard of as a pulmonary embolism, or PE, except instead of a clot, this is air blocking the flow of the flow of blood through the heart. Most commonly, the venous air is entrained in veins lining the skull. They're called dural sinuses. They're formed by infoldings of the dura mater, which is a tough, gristly-like tissue that lines the skull, but also has infoldings and serves to form veins in the skull. Because the veins are made of dura, they are not very elastic. They don't collapse when they're cut. They're stiff-walled. And so if there's a path for air to get in from, say, a skull fracture, then air can be pulled into the dural sinuses and drawn into the heart. And so those case reports involve that, and I had x-rays that we took at the medical examiner facility, and I enlisted Dr. Guidi to provide a professional radiology perspective.
Okay, so it looks like you have some 25 books listed there. We're not going to go through them all. Let's go to chapters in medical books and review. There's one guideline for reports by autopsy pathologist.
First, I just need to...
Yes.
Okay, and let's just move on past those books and those sort of things, but you also authored chapters in books that deal with the practice of autopsy, correct? For the handbook of autopsy practice?
Yeah, I did some chapters in Ludwig's book, Handbook for Autopsy Practice. He was a mentor at the Mayo Clinic. And then the other one was the Spitz. It's known as Spitz. He's the senior editor, called Medical Legal Investigation of Death. And that was a predominant forensic pathology textbook in the 80s and 90s. And I did 2 chapters in 2 editions of that.
And were you also involved in practice guidelines for Florida medical examiners?
Yes,
And that's over a period of years, correct?
yes.
In addition, you have numerous presentations that you've been involved with, correct?
At professional societies, yes, a few, yeah,
Lectures as well.
yes.
Now, in this particular, let me ask you this, have you ever been qualified as an expert in the field of pathology and the field of medicine?
I've been qualified as an expert in the field of forensic pathology.
Okay, and how many times?
Over 300, could be 400. I never kept count, so that's an estimate.
In state and federal court?
Yes.
And how many autopsies do you think in your career that you have performed?
That I have counted. It's 6,800.
What percentage do you think of those were as a result of gunshot wounds?
Well, let's do it this way. About 10% were homicides, and most of the homicides, probably 2/3, were from firearms. And then there are accidents. There aren't that many accidental firearm deaths. There are a few hunting accidents. And then there are suicides, almost all of which, if they involve firearms, involve handguns, but some long guns. Suicides would be about maybe 25% of a medical examiner practice, and the firearms deaths and suicides would be maybe half that amount in Florida. So what that all totals up to, I don't know.
When you say homicide, that's opposed to suicide or accident. Is that fair to say?
Yes, I use that in the sense that we use it on a death certificate, where those terms are intended solely as an aid to the vital statistics people who have to classify causes of death. And those designations are only to assist in figuring out the cause of death when the cause of death is not expressed correctly on the certificate. They have other questions of a similar ilk, such as, did the decedent smoke? Where did the injury occur, and that sort of thing, all designed to help them deal with causes of death that aren't written quite the way they should be.
In other words, my question to you is, the medical examiner, if they put the cause of death is homicide, they certainly aren't commenting on whether that homicide was justifiable or not.
No, and it's not even binding on anybody. It's not binding on a court. It's not binding on any lawyers. It's not even binding on the Register of Vital Statistics in Jacksonville. Why the Register of Vital Statistics for the state is in Jacksonville and not Tallahassee, I don't know. There's a story there, and I don't know what it is. But that's where it is.
Now, for this particular case, you were provided, for instance, an autopsy report of Chad Oulson.
Yes.
You were provided some photographs.
Yes.
Including the photographs of the autopsy of Chad Oulson, Mr. Oulson?
Yes.
Okay. At this time, I'm going to show you a photograph that's already been entered into evidence by the state. It's State Exhibit number 60. Thunderbird, if I may.
Yeah.
I just move this up just a bit, Your Honor. Not too far. Okay, we're ready. If you would, may I have the witness step down, please? If you would step down, please, doctor. Dr. Adams, here's a stylus. You want to indicate some areas that we're about to talk about. This is a photograph that's been entered into evidence by the state of Florida depicting an autopsy photograph of the right hand of Chad Oulson. You saw similar photographs in the ones that we provided you, correct?
Yes.
In fact, you've seen this exact photograph.
Yes.
Now, let me ask you, as we look at this photograph, we are looking at, that looks like the right hand, is that correct?
Yes.
Is that proper medical technology, or is there, terminology, is there another name for right hand and left hand?
Probably in Latin there is, but I say right hand.
Okay. Now, we're looking at something at the very top, this area right here. Assuming that what we're looking at is a result of a gunshot wound, what are we looking at in that particular area that is underlined in black?
The thing that you just underlined in black is the actual wound created by the bullet. It's gouging out a trough from the tissue of the wrist on the radial side. I'm going to say radial and ulnar. Radial would be the side with the thumb, and ulnar would be the side where the little finger is. It's named after the bones in the forearm. So this is on the radial aspect of the wrist. And the other thing you see here are all these reddish purple, almost sometimes black dots
Now,
on the
before we
skin.
get there, let me ask you a question. The orientation of this photograph, again, assuming it was a gunshot wound, what is the orientation? In other words, where would the firearm be in relation to this hand, this photograph of a hand?
This photograph is taken so that the lens is oriented almost the same way the muzzle of the gun was. So that you're essentially looking down the sight of the gun when you're looking at this picture. I mean, the picture, there could be other photographs that are taken on the other side of the hand, and that wouldn't be the case for those photographs, but it is for this one.
Now, you were indicating these purple-looking areas. Let's talk about that. What is that?
That's gunpowder stippling. That's caused by having partially burning flakes of gunpowder strike the skin. They can strike other things too, but in this case it's the skin. Some of them, the flakes stay in the skin. The more the body's handled, the more they fall out. And others, like these pink ones, it's just a little divot in the skin, a little scrape. By itself, it's non-specific, but you can judge it by the company it keeps. This pattern is one of gunpowder stippling. The gunpowder stippling effect like this, where you see stippling but no soot, is typically for a standard handgun anywhere from 2 to 18 inches from the muzzle.
Now, let's talk about, you said no soot. What would soot be an indication of?
Soot is deposited when the skin is within a couple of inches of the muzzle. Beyond that, the soot doesn't, it's not apparent.
So the range between the muzzle, which is what, the very tip of the firearm,
Right.
to the wound itself, based on the stippling, is what's the range again?
Somewhere between 2 and 18 inches. This is moderately dense, so it's somewhere in the middle of that range. It's probably not out to 18 inches, and it's probably not 2 inches.
And what else does this kind of grouping of stippling tell us in terms of location of the firearm? In other words, my question is, why do I see more stippling in this area that I've drawn a square around, and less stippling in this area where I've drawn a square number 2 around?
Those flakes of gunpowder come out in a cone, if you will, and more of them are close to the center of the cone than to the outside of the cone. So you would expect more dense stippling close to the bullet, where the bullet goes, and it's a more dispersed pattern away from it. Now here, of course, this no skin up here, the bullet's grazing the wrist, and this isn't aligned exactly with the muzzle. You can see up here along the radial aspect of the wrist, you don't see any stippling, but if you took that hand and rotated it just a little bit like this, then you would have the lens of the camera lined up just the way the muzzle is. And you wouldn't be able to see this unstippled skin that you see in this photograph, because it's not exactly lined up. The lens isn't exactly the way the muzzle was.
Now, I notice way out here, put a little triangle, we see what may be a speck. As we get further out to the left, away from the knuckles, we see what appears not to, an area that appears not to have any stippling.
Yes, to the left of the triangle, no stippling. You can see some freckles. Within the stippling, within the triangle, you can see some freckles. And then you have this to the left side of the midline of the triangle. Is it a stipple or is it a freckle? I don't know. It's easy to judge it by the company it keeps, and most of these are therefore stippling. Out here, could be either one, because there's so little stippling out here.
Now, let's look at the fingers, what we can see of the fingers. Let's look at this finger right here.
All right. Mr. Michaels is pointing to the fourth finger and the proximal phalanx.
And
that's a word for the bone in the finger. 3 phalanges to each of the 4 fingers, 2 to the thumb. I mentioned that only for the record.
I appreciate that, and I won't remember what to call it again, but I appreciate that.
The court reporter will.
Thank you. And so I don't see any stippling there. Is there something that I'm missing? Do you see any stippling there?
I don't. It's a little bit in shadow, but it's illuminated well enough that you can see that you can't see any gunpowder stippling on the skin of those proximal phalanges of the fingers.
Now, based on the pattern that we're seeing of the stippling, if the fingers were extended out, would you expect to see stippling in that area?
I would. If you look at the way the stippling peters out here on the forearm, it should extend out about the same distance here if those fingers were in the line of fire of the gunpowder flakes. And we don't see that. So you can conclude that those parts of the fingers were not in the line of fire of the gunpowder flakes. Either the hand is flexed or there's something shielding the fingers.
And when you say flexed, are you talking about like closed, like grabbing something?
Flex means, right, the fingers are closed. My anatomy professor said the easiest way to remember flexion and extension is to picture a bear cub on a telephone pole. Everything that makes the bear cub hold on to the pole is flexion.
And would the stippling and the lack of stippling on the fingers be consistent with a hand that at the time that this trench and this stippling was created is what we see consistent with the fist?
It is.
Okay, thank you. You can take your seat again, please. Well, Your Honor, maybe not. Maybe we can use the demonstrative aid at this point. Can we turn this off, please, Mr. Thunderbird? What we're going to do, Doctor, we're going to talk about some of the body's vulnerabilities. I have here a demonstrative aid, a model of sorts. Would that model help you explain to us the areas of vulnerability and why they might be vulnerable?
Yes.
Okay. And I'm talking about when we talk about trauma, blunt force or otherwise.
Yes.
Okay. May I, Your Honor?
Amen.
You can go down, please, Doctor. All right. Certainly you're familiar with anatomy of the human body.
Yes,
and the skeletal system.
yeah.
You've probably seen it over the 6,800 times you talked about.
Some parts more than others, yeah.
I understand.
Right.
The most vulnerable part of the body?
Probably the head or the junction of the head and the cervical spine.
Let's start with the head. Tell us why the head is such a vulnerable area of the human body.
All right. I'm pointing to the temple here. And this part of the skull is called the temple bone. It's fairly thin there. So this part of the skull, being thinner than the rest of the skull, is more susceptible to impact, to fracturing. And then the whole structure of the face.
So let's talk about the temple first.
Sure.
Okay. So the temple area is,
The side of the skull, just above and behind the eye socket.
okay.
The
And
orbit.
on the human body, it looks like this part here?
Yes.
Okay. And so this is what it looks like behind the face, right?
If you will.
Okay. And so tell me why this is particularly vulnerable in terms of fracture. Is it the structure? Tell me what it is that makes that area so vulnerable.
It's thinner than other parts of the skull. Other parts of the skull are thicker, not so much to protect from injury, but because they have muscular insertions. For instance, the masseter muscle comes up here and inserts. In gorillas, it goes up onto a crest on top of the skulls because the muscle is so powerful, they have to crack nuts. And humans, not so much. The skull is thicker back here. All the neck muscles are inserting.
Let's talk about the skull in a moment. When it comes to the temple, based on the structure of the bones, by that I mean the lack of density that other bones may have, you said it's more susceptible to a trauma. Would that be a trauma caused by a fist that could potentially fracture the temple?
Could be a fist or a blunt object. Anything that provides impact.
Okay. Or even a slap that's done hard enough with the heel of the hand, for instance?
Probably not so much a slap from an open hand.
Okay.
Because the force would be distributed. The injurious potential of something coming at the body is inversely proportional to the time over which it's inflicted and inversely proportional to the area over which it's inflicted. So if it's inflicted over a long time, it's less injurious, short time, more injurious. This makes sense if you think about the difference between blast injury, impact trauma with, say with cars where there's conservation of momentum, you have enough speed, or just slow compression. Blast injury is much worse. Slow compression is much better. And then that's the time element. If you look at the surface area element, if all the force is concentrated in something small and hard, it's more injurious than if the force is spread out over a wider area. And if you think about a motorcycle helmet, it's designed to spread the impact out in time, that's the pad, the liner, and in space, that's the shell.
And so, for instance, if something that's a cell phone, if it were to strike somebody in the temple on the edge, is that potentially the cause of a fracture to that area?
Yes, it could be, yes.
Now, let me ask you this. If somebody's a fat guy, has a lot of fat, weighs a lot, is that going to protect him in any way from that sort of injury you're talking about when it comes to the temple?
No. I mean, there's a little bit of extra fat in the scalp. People who are obese, particularly morbidly obese people, but it's not much. Their increased fat depots are largely elsewhere, usual places, the abdomen, buttocks, to some degree on the extremities.
Now, I know you're talking about the face, what about other parts of the skull? Let's talk about that.
Well, before we leave the temple, I wanted to mention the epidural hematomas. There are arteries that supply the skull, and they run on the inside of the skull, between the lining dura mater, I mentioned that earlier, and the skull itself. So if there's a fracture and the two pieces of bone are displaced during the instant that the fracture occurs, then one of those arteries can be torn. The one most likely to be torn is the middle pharyngeal artery, which is right here in the temple region. So if you get a tearing of that artery, the person doesn't bleed to death. What happens is there's an accumulation of blood, arterial blood gets pumped in, and it strips the dura off the skull, forms a hematoma, and then that dura, being pushed by the hematoma, presses on the brain. The brain doesn't like it when it's subjected to local pressure like that, and the brain then shifts. It can herniate through holes in the base of the skull if there's enough pressure, or the brain can simply develop swelling and edema in that area where there's increased pressure.
While we're talking about the brain, let me ask you this. As a person ages, does that affect the size of the brain within the skull?
It does. With advanced age, the brain actually shrinks.
Would it help you to be able to illustrate that for us?
Sure.
To explain it? Mr. Funderburk? If you would, let's draw nice and big so we all can see it, please.
I'm not a great artist, but I think this might help to illustrate it. So this is, I want to sketch this, a coronal section of the head. The skull is this, it's two black lines with cross-hatching filling in the space. The brain is this sort of U-shaped round thing in the middle with the dots. I tried to make dots.
Now, I'm sorry, doctor, when you said coronal, is that if we take the top of this off?
No.
We're looking down?
That would be a horizontal section. A coronal section is a vertical slice from left to right. So just imagine this is a vertical slice from left to right. If I drew a couple of ears on that, it might help, but I'm not drawing skin. And then the inner layer of the skull here, this black line, that's where the dura mater is. That's the lining of the skull. And then there's a projection of dura right here that is between the cerebral hemispheres. Not completely between, just part way. And that's just, the dura, as I mentioned, is tough, bristly-like, and it's flat. And then the veins that drain the brain drain right up into the base of that falx cerebri, which is that, it's called that because it's sickle shape. That's falx, Latin, I guess. Now, I'm going to sketch an older version of the same thing. And I'm going to just exaggerate. I didn't mean to make the skull thin here. You can ignore that. So again, a brain, the skull, and The space between the brain and the skull here is increased because the brain is smaller. And this space would be occupied by cerebrospinal fluid. Again, we have bridging veins going from the cerebral hemispheres up to the falx cerebri. And because the brain is smaller, those veins have to be longer. They traverse a longer distance. And tearing of those veins is the majority cause for subdural hematomas. You may have heard of someone elderly who fell and got a subdural hematoma. And that would be an accumulation of blood in the subdural space, where I just drew an arrow. And if there's enough blood, it will push on the brain with bad effect. There's more room to accumulate blood here before symptoms appear, but on the other hand, the bleed is more likely to happen because those veins are longer and more susceptible to being torn. What happens is if a person falls, I'm just going to draw a head in a couple of feet. I've drawn one stick figure upright and one stick figure supine or recumbent. And for the head to get from here to here, it rotates through 90 degrees. The skull and the brain are moving at the same time. The recumbent person has struck the floor or the ground or whatever it is. So the skull stops suddenly and the brain continues to rotate until it snaps back. That rotation is when those veins are torn. That's how a subdural hematoma works. So just to complete this, I'll sketch a child's brain. Almost no space between the brain and the skull. There's very little room for subdural blood to accumulate. They get symptoms right away, but they're less likely to have tearing of the veins because they're so short.
So as we age, we're in more danger. Should we be in a situation where either we fall, right?
Yes.
Or are pushed down,
Yes.
or go down as a result of a punch, for instance?
Yeah, from the viewpoint of the skull and the brain, it doesn't make any difference what the impact is.
Okay. All right, back to our model here, if you will. So we talked about the temple, about the brain. Let's speak a little bit more about the skull before we get to the face.
All right, I'm gonna check. Can we prove?
Yeah.
you would please step down, doctor. We were talking about the skull.
I was just about to move on to the junction of the skull and the cervical spine. I'm going to turn this thing sideways. And there are 7 cervical vertebrae. The one at the top is kind of like a washer, and the bolt for the washer is a portion of the second vertebra that sticks out. Reptiles don't have this arrangement, mammals do. If you consider the complete turning capacity of the head and the neck, 40% of it occurs right here. That's why we can turn our heads like this easily, and why alligators look kind of silly when they run, because the head moves with the torso, because they can't turn the head the way a mammal can. So this is an area of weakness. It's nice to be able to look around without moving the whole torso. There's maybe some evolutionary reason, I don't know. But it's an area of weakness. And this comes to light in traffic accidents, where people get devastating injuries because the ligaments here fail. And this junction, the cranial-cervical junction, dislocates and lacerates or contuses or sprains the junction of the brainstem and the spinal cord. Now, if we're not talking about traffic accidents, we're just talking about an impact from a blow of some kind, you can actually, a blow right here, and I'm indicating basically the mastoid process or the side of the upper neck, can produce enough transient dislocation to tear either one of the 2 vertebral arteries that run up through the bones of the vertebrae and then converge behind the brainstem, or in front of the brainstem, I should say. It can tear those and produce a subarachnoid hemorrhage, where blood fills the spinal fluid space around the brainstem and the spinal canal. And that can be instantly lethal or cause death within several hours. Or someone could survive, but this can cause a problem with just a localized blow. To the right side, I don't mean right in the sense of right-left, but to just one special part of the head, whereas the same force and the same spatial distribution of a blow elsewhere in the head might produce just a cerebral concussion or just irritate the victim.
We done with the head area yet? I know we haven't gotten to the face.
We'll turn to the face. I'll just turn this a little bit. The mandible is fairly strong, although there are some weak areas. The condyle will tend to fracture here, and the other fractures tend to form near the canine teeth. But then if you think about it, the facial bones, there's this whole structure of thin bones enclosing air spaces, either the nasal passage or paranasal sinuses, commonly known as sinuses, that provide resonance for a nice speaking voice, or a nice place to create an abscess if they don't drain particularly well. We've all known people that have had sinusitis, which has been a big problem for them. But because these bones are thin, they can be fractured with some kind of blow to the face. This is the cheekbone here, the zygoma, and this can get fractured easily. Say, for instance, boxers or anybody who gets a blow to the face. And you can get other facial fractures. In traffic accidents, you can get a fracture right through the junction of the maxilla and the nasal bone, all the way through, all the way across, so that one part of the face is completely dislocated from the other part, transiently, with a tendon severing of arteries.
So the cheekbone, this area here, it looks like the structure is it's very elegant looking, but it also doesn't look very sturdy.
Right, and you just put your finger in the space where the masseter muscle goes.
And would that protect this at all? This bone? Or to
Where
be
the muscle,
shrunk?
No, the muscle lies beneath the bone. I guess it would tampen at it a little bit, provide a pad effect.
But it wouldn't stop this bone from being broken by a blow of some sort, including a fist?
No, it would not.
And when you talk about the jaw, again, that's vulnerable in terms of susceptible to being broken with a blow, including from a fist?
Right. And a blow to the chin can drive the condyles up into the base of the brain. That's something seen more in traffic fatalities where the force is substantial. And then there's the nose. The bones of the nose go right up toward the base of the skull. The base of the skull is quite thin there, so it is possible to have bony splinters from the nose be driven into the brain.
Teeth, possible to fracture teeth with the fist?
It is possible to fracture teeth depending on how well they've been taken care of, and equally likely to fracture the maxilla or the mandible.
But certainly if, depending on one's bite, if one were to strike the right area, certainly you would chip or break a tooth that's maybe not directly struck. Would you agree with that?
Sure, ask any hockey player.
Okay. Where do we go to next on this model, doctor?
Well, we have ribs. All bones have some elastic fibers in them, so it helps the bone to bend when it's struck. Speaking of hockey players, you see them get knocked down on the ice and they get right up. Their bones are bending and then snapping back. Now, they're young. In the elderly, much of that elastic component is lost, and the bones become more brittle. They don't bend very easily. And you see this portion here of the rib is kind of translucent on this plastic model, and this portion of the rib is opaque and white. This portion, the opaque white portion, is true bone. It's hollow in the middle, it's narrow to be sure, but it's bone. The translucent bit here is intended to depict cartilage. The portion of the rib that connects to the sternum in a young person is cartilage. So it's stiff, but it's rubbery, and it can absorb energy and release energy. These cartilaginous portion of the ribs gradually become calcified with advancing age, or even ossified, which means they actually just turn to bone. And with advanced age, the junction, the joint between the rib and the sternum can actually become fused. Ankylosing is the technical term, so that there's no joint anymore and the joint doesn't bend. Rib fractures, of course, can be produced by a localized impact to the chest cage, the thorax. And
So let me ask you this. So an older person, you describe this area here, I guess these areas, the translucent area
right.
of the rib cage as becoming ossified? Is that the word?
Ossified, O-S-S, osseous.
And does that mean instead of being flexible and being cartilage-like, they get a little stiffer?
It gets stiffer, yes.
And are they more susceptible to fracture in an older person who has that
Yes.
condition?
So I was talking about rib fractures, and I was about to mention what happens when a rib is fractured. The rib fractures are painful, so the body tends to minimize the movement of breathing on that side. So there's less air moving in and out of the lung on the same side as the fracture. It's called splinting. Just as you can reduce the movement of a fracture of the tibia, for instance, you've got a proximal and a distal part of the bone on each side of the fracture, and you want to align them and then immobilize them, and you do that with a mechanical splint. So the body tries to achieve the same thing by just not breathing very much on the side of a rib fracture. That's called splinting. And what happens when you don't ventilate a lung is that it's more susceptible to pneumonia. And if there's a lung contusion in the same area, that also independently increases the risk of pneumonia.
Where to next? The abdomen?
Well, let's talk about the abdomen. The liver sits here. It's part of the peritoneal cavity, so it's an abdominal organ accessible by an abdominal surgeon. But the diaphragm, that big muscular slab, if you will, thin slab, that separates the thorax from the abdomen, it's domed up on both sides, and the liver sits up under there. So the liver, if you're not taking a deep breath, the liver sits up in the thorax from a mechanical point of view. And if a person takes a deep breath, the diaphragm descends because the muscle contracts, and the liver is allowed down a little bit. So if the abdomen gets a blow while a person has just taken a deep breath, then the liver can be lacerated. And the spleen, same thing over here, normally protected by the rib cage, but during a deep breath it descends and it's more susceptible to a blow.
Are we done? We have
Well, we can talk about the testes in a man. They're richly innervated, extremely painful when an injury occurs. And so a blow to the testes, for instance, a kick, in a person with heart disease, or even without heart disease, but usually with heart disease, can cause the heart to stop because the pain increases the sympathetic tone in the autonomic nervous system. Increased sympathetic tone increases the risk of a ventricular arrhythmia of the heart, either ventricular fibrillation or asystole or ventricular tachycardia. So a kick to the testes can produce instantaneous death. Not always, but it can do it, and it's been well documented.
Now, in terms of aging, you talked about how it affects this cartilage-like area in the rib cage. What does it do to the skeletal system in general?
In general, the bones become more brittle because they lose elastic fibers. And being more brittle, they're just more susceptible to fracture.
So an older person might suffer a fracture, or a younger person might not from the same blow.
Yes.
You can take your seat.
Okay.
Go ahead, Mr.
All right, let's talk about the anatomy of a fist, okay? Why is a fist more likely to cause injury than an open hand? First, let's talk about a fist. What happens when you go from this to making a fist?
When the fingers are flexed into a fist, and the thumb can either be put in front of the fingers, which is what Americans think of as a fist, or in some societies the thumb is put between the fingers, but either way, when there's a fist, more force can be delivered with a fist below because the kinetic energy is from the blow is being transmitted not only to the hand bones, but up into all the way up into the shoulder and even the torso. So the energy isn't all being absorbed by the hand, so more force can be delivered.
And what about the idea of the kind of the shape of the fist? We have, I mean, in layman's terms, knuckles, right? Are those more prominent when you make a fist?
They are.
You certainly have this area between the joint, between the phalange as well, correct?
Right, there's a series of joints, right.
But these become more prominent and actually stick out when you make a fist.
Well, the key thing is that they're rigid so that they with a fist, particularly if there's say a roll of nickels or something, there's a slang term for that, I forget what it is. But this all serves to increase the buttressing effect of the fist so that everything's tight and solid, and these knuckles are not going to flex more or extend more. They're going to be solid, and the fist then becomes, for purposes of physics, one unit. Whereas if you have a hand, then you have all these individual bones and several units. The other thing that happens with a fist is that I mentioned earlier that if the force from a blow, it makes a difference whether the force is distributed over a small area or a large area. A fist delivers the blow over a smaller area than an open hand would.
Would you agree or disagree with me that the fist can cause a nose fracture?
Yes,
Can a fist cause a tooth fracture?
yes,
Can a fist fracture the squamous part of the skull?
the squamous part of the temporal bone that I talked about, yes, that's the thin part, with sufficient force, yes.
Okay. What about a brain contusion?
Any blow to the brain that's substantial enough can produce a brain contusion, particularly if the head is moving and the striking object is fixed as in the floor, but you can get the same effect with a moving object and a moving head. Really, there are very few situations where the head can't move. It's injurious to have a moving head.
What about a fist being able to cause a rib fracture?
It could, with sufficient force, yes, and an elderly, brittle rib.
Okay. So an elderly individual would be more susceptible to a rib fracture from a fist than somebody who isn't elderly?
Yes.
Now, certainly in your career, you're familiar with a one-punch homicide.
Yes.
What does that mean?
That's when death is inflicted by one blow delivered by a fist. And I mentioned a couple situations when I was handling the skeleton. One is the blow to the side of the neck, causing a transient dislocation of the craniocervical junction and laceration of the vertebral arteries or branches of the vertebral arteries and a subarachnoid hemorrhage. That was described in a publication by Dr. Kontostavlos back in the late 80s. And it was called a Kontostavlos lesion for years after that.
You want to approach? Go ahead.
Doctor, certainly based on your years of education, your training in the field of pathology, your work in the field of pathology, you're familiar with that phenomenon of a one-punch homicide.
Yes.
And you're certainly familiar with the manner in which that happens.
Yes.
Now, in this case, you had a look at the autopsy photo of Mr. Oulson's hand, and in your opinion, is the injury combined with the stippling consistent with that hand being in a fist when it was injured?
Yes.
May I have a moment?
You may.
Let me ask you this, Dr. Adams, in your experience as a medical examiner, certainly you've seen police officers and detectives actually attend autopsies.
Yes, I encouraged it.
Nothing further, thank you.
Cross? Yeah, are we done with this?
Good afternoon.
Good afternoon.
I want to begin where Mr. Michaels left off. We talked about how the hand is positioned and what I think you refer to it as clenched. Is that the term that you used?
Well, I didn't, but you can,
Flexed.
that's fine.
Flexed? Is that the word?
I did
you
use the word flexed at one point, yes.
Okay. And yeah, you gave an example with the fingers into the palm.
One was the fingers wrapped, the thumb wrapped around the fingers, and one was the thumb between two fingers.
Okay. Now, you can use me as an example when our hands are just hanging loose. Are our hands straight out like this, or is it natural that they are curved?
I didn't understand the question.
Sure. When your hands are just naturally by your side, you're not moving at all. You see the position of my hands?
Yes.
All right. Is that just, as we're walking along, that's just the way our hands hang, right?
Right, that's a neutral position.
Okay. I was looking for the term.
Right.
So a neutral position is, that's why Lego figures look like this, I guess. They're just that, they're like this, right? They're just hanging out.
I don't know what you mean by a Lego
Well, you
figure.
said this is the neutral position, right?
When you said Lego, did you mean like the toy, the L-E-G-O?
Yeah, that one, that's the way their hands look.
Oh, okay, that's lost on me.
No, okay, all right. But the hands are in a neutral position. They're not straight out, right?
Right, that's
And
extended.
they're not flexed or clutched,
Right,
right?
right.
They're in a neutral position, so just kind of halfway in between.
Right, okay.
Right. Now, you would agree that when we looked at the photograph of Mr. Oulson's right hand, that the hand in a neutral position would also place the fingers out of the cone of stippling that impregnated his back of his hand and his, is this the ulnar area that you called?
That's the radial side.
Radial side, right? So if the hands are in a natural position, the fingers would also be out of the cone, correct?
Well, I wouldn't quite agree with that, because in the photograph where I pointed out that the position of the lens and the position of the muzzle were almost the same, you could see the proximal phalanx of the four fingers. They were in view. That was a neutral position. Things tend to assume a neutral position after death, even though there's rigor mortis. So that photograph was a neutral position, and there was no stippling on the skin.
All right, so I'm going to use my right hand here, right? And you know that the path was front to back, left to right, right?
For the wound path through the torso.
Right, and we have
Not very much left to right, pretty much front to back.
Okay, but as we move, then this is not going to be exposed, correct?
As you move what?
If you have, everything's dynamic, right? When you're shot, it's a stationary, almost like a picture, right? But if our position can be anywhere before we're shot, so if it's a little bit front to back, a little bit left to right, if the hand is in the neutral position, as you say, then the fingers are not going to be in a position to have the stippling, correct?
Well, the way you have your hand positioned, it's a neutral position for the fingers, but they would be exposed to gunpowder.
The gunpowder is from here to here, correct?
In the photograph, right.
Okay, and there's nothing on the fingers?
So
right?
something was either shielding those fingers, or they were flexed so that the fingers were not subjected to the gunpowder.
And they could be flexed in the neutral position, could they not?
Well, that's an oxymoron. They're either flexed, extended, or they're in a neutral position. They can't be both at once.
All right, so let's talk about in a neutral position. It's also consistent with being in a neutral position, is it not?
What is?
When the person was shot, and the stippling that we see is also consistent with the hand being in a neutral position, is it not?
The only way to make it into a neutral position is to have the hand bent so far this way that the fingers are not exposed, and then the wound path across the wrist would then be angled. So it doesn't work.
the wound path is approximately right here, correct?
Yes.
Okay. And so we have the straight line, right? So we have this that bends, right?
Yes.
Right? So if this is flexing and it's here, 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 it could be like that and still have the straight path, correct?
That wound on the wrist was actually a little bit at the base of the thumb, so it's, if you bend the wrist, the wound path, that wound, the area where the bullet went, is going to move a little bit. So again, it doesn't work.
Page 1115. You remember testifying in a previous hearing?
Yes.
Right. And that time you were placed under oath
Yes.
and testified as you have here?
Yes.
Can you ask the question to give me a line, please, on that page?
Page 1115, line 17 through 25, page 1116. Lines 1 through 5. Now, we were talking about the stippling, and we've been talking about whether or not it would be on the fingers. And the other possibility is just the cone did not go that far, correct? The cone of stippling. It just didn't spread that far, correct?
No, we know how far the cone spread because of the spread on the forearm. So
Okay.
the only way for it not to have stippling at an equal distance on the fingers is if the fingers were flexed and out of the way, or if the fingers were shielded by an intermediary object.
At that hearing, do you remember being asked this question?
Your Honor, may I make much objection? Improper objection.
You remember testifying at a previous hearing?
Yes.
All right, and you were asked questions under oath?
Yes.
And you were giving your medical opinions during that particular hearing, were you not?
Yes.
And it's important, wouldn't you agree that that you provide accurate information to the jury?
Sure.
Now, before we went up to the bench, I asked you about, is the lack of the stippling on the fingers, is that consistent with the cone of stippling not being that wide? And your response was that, yes, we know the cone of stippling because on the wrist. Remember that?
No, I don't. Perhaps
That's
you can
what you
show me the
just said.
transcript.
Huh?
I don't remember it, and maybe you can show me the transcript.
No, sir. That's what you just said 5 minutes ago. We know the cone of stippling because we can see it on the wrist, right? I mean, on the forearm. You just said that.
Oh, yeah, that, yeah.
Okay. Now, at that hearing, I asked you, all right, it's also consistent with the muzzle being at such a distance from the wrist that the cone is so small in diameter that it just didn't cover past the knuckles, correct? His fingers could have been out and the stippling just didn't make it that far because it's so close. Answer, yes. Do you remember saying that?
No, but I don't dispute that. That's in the transcript.
All right. Mr. Michaels went through a series of questions regarding the vulnerability of certain parts of the human anatomy, including the head area and the torso area. So I'd like to go through those with you, all right?
Sure.
Okay. I'm going to use very layman terms. You can use the medical terms to put it in what I'm talking about, okay?
Sure.
All right. Now, I'm going to go through the injuries that you talked about, and I'm just going to bullet them out first, okay? And then we'll talk about them. You talked about the left and right temporal area, correct?
I did.
Where the bone is thin?
Yes.
Okay. You also talked about the orbital sockets of the eyes?
Yes.
All right. You also talked about the nasal cavity?
Yes.
And you talked about the cheeks where the muscles underneath the bone. Remember that testimony, that area right here?
Yes.
Okay. You also talked about the neck, not only the hitting in the side of the neck, and you used the skeleton to show how that can result in spinal fluid going where it's not supposed to be, right?
I did talk about spinal fluid, but I didn't talk about spinal fluid going where it's not supposed to be. I talked about blood going into where
Blood.
spinal fluid is supposed to be.
Very good. Thank you. All right. And then we talked about the jaw being broken?
Yes.
Okay. Now the witness step down, Your Honor.
May I, Your Honor?
You may.
Thank you. Your Honor, may we approach?
Yes.
Object.
Okay. You may.
Just have a moment, Your Honor. When we talked about your previous testimony regarding the stippling on the hand, we talked about what you testified to at a previous hearing and what you testified here today. Let me just ask you one or two questions about that topic, okay?
Sure.
So you know where we're going.
And I asked you to look at the transcript so I can see the context and not just the isolated quote.
Well, maybe your attorney would want to do that. I don't know. In that statement, you would agree with me, now that you've seen that statement, or that I've read it to you and indicated yes, that the hands being in such a manner so that when the cone actually spreads, it doesn't hit the fingers. That is also consistent with no stippling on the fingers, correct?
Well, first of all, I don't understand the question the way you've constructed it. And secondly, you're referring to testimony in the transcript which you won't let me look at. So you can repeat it every time if you want, or you can let me look at it. But at this point, I don't remember the wording in it because I can't see it.
I read it to you. It was something about the words you didn't understand?
No, but I don't have it in front of me now. I don't remember exactly what the wording of the sentence was.
All right, I'll read it to you again.
Your Honor, I believe what I hear is that the witness is saying he doesn't remember the context, so if the prosecutor would be so kind, the court would instruct him to present it to Dr. Adams so that he can refresh his recollection. It sounds like that's what we should be doing here.
I'll agree. Go ahead and show it to him.
First witness, Judge? Just slide that over, Phil. Read page 115 and 116. Can I just stand here for a moment?
Sure.
Well, it looks like I didn't understand the question as you asked it. It
Your
was
Honor, I
clear at
object
this
to,
point.
no, I object to the witnesses making any statement other than when I ask it.
All right. Fair enough. Ask a question.
I was trying to answer the question as to whether or not he.
I haven't asked the question.
At this point, I don't know if there's a question pending. Ask the question again, please.
Did you have a chance to read the statement?
I did. I'd like to have it back so I can refer to it while I answer.
Did you have a chance to read the statement?
I said I did.
All right. And do you agree that's what you said at a previous hearing? That if the cone wasn't wide enough, that would be another reason for the stippling not to be on the fingers? Is that was your testimony at the previous hearing?
It probably was, although...
Excuse me, Judge, that calls for a yes or no. Was it your testimony at the previous hearing?
I did not review this transcript after the hearing.
All right. Just,
So if we assume the transcript is correct, that's an assumption.
just let him answer. Let him answer. Go ahead.
All right.
This is totally dependent on the accuracy of the court report. This isn't like a deposition where I get the chance to review it and make an errata sheet. I had no opportunity to do that, and I had not seen this thing until very recently. So I can't vouch for the correctness of whether this is reported correctly.
What's your hourly fee?
$4.50.
How much are you getting paid to be here today?
Same thing.
$4.50 what, an hour?
Yes.
And how many hours have you been here today?
I got here at noon.
All right, so it's 4 o'clock, $1,600?
Yeah, that sounds about right.
$1,600 in your pocket today. How many hours have you spent on this case prior to coming into this courtroom?
From the very inception,
Yes, sir.
I didn't look at the invoices, so I can't tell you. Recently, just preparing for this trial, it's probably about 3 hours.
All right. And since the inception of this trial, how much have you been paid?
I don't know, because as I just said, I haven't looked at the invoices. I can't answer the question either for time or dollars.
All right. At the previous hearing, you would agree you were there about 4 hours also?
Sounds about right.
And prior to that previous hearing, you also had an opportunity to review material and fill out your invoice for that time?
Yes.
All right. So right now, we're at least at $3,200, another, what? Are we somewhere in the ballpark of what?
I don't know. What you say sounds good.
All right. And your testimony here today is, I don't believe what the court reporter wrote, therefore, court reporter must be wrong and not you. Is that your
No.
testimony?
I didn't say that. I said I can't vouch for the accuracy. If it's accurate, then it looks like I didn't fully comprehend the question as you asked it.
All right, let's talk about
Because my
that.
opinions haven't changed, and that
All right.
photograph hasn't changed.
All right, well, let's talk about that. At the time of the previous hearing, did you have an opportunity to say, Mr. Martin, I didn't understand that, like you've done a couple times here today?
I did.
All right, and in that particular section, you've read it, Did you say, Mr. Martin, I don't understand that question? You
I didn't
didn't
get-
do that, did you?
I don't think so, but I didn't get the chance to turn the page and see what was on the next page.
Thank you, no further questions.
Redirect?
Thank you, Judge. May I approach the clerk?
You may.
Exhibit 60, please. Thank you. May I have the doctor step down? Step down, please, Dr. Adams.
You may.
I'm sorry, Judge, I saw you shake your head, I didn't hear it. This is Exhibit 60, this is what we were talking about. You see this?
Yes, that's the same photograph, just a print form.
All right, now let's talk about this whole issue with testimony of the prior hearing. Why on this photo is it impossible that this stippling could have, the lack of stippling on the fingers was caused by having this hand closer to the barrel? What about the cone? What are we talking about here?
Well, the cone I mentioned is the gunpowder flakes issuing out, and not a cylinder, but a cone. It's the farther from the muscle, the farther they disperse, the wider the dispersion.
Let me interrupt you for a second. So the middle of the cone is where the bullet comes out of?
Yes, so the
So
flying
this-
bullet is surrounded by flying pieces of gunpowder.
So this injury right here is the bullet?
Yes, that's the center of the cone, if you will. And we can see here that the stippling extends out this far on the forearm. And if you take that same distance over here, that measurement goes out to the second knuckle of the fingers.
And if we had a muzzle that was closer, would we see the stippling out here?
No, the stippling would be concentrated. Those stipples would be closer together, but not spread out so much. Just the same number, actually more, because the gunpowder that didn't hit the hand because it went beneath it, some of that in a concentrated cone would actually be on the wrist of the hand.
And we don't know from what you read and what you were shown, what photos or anything else that were shown to you at that point to ask you that question, do we?
No, I couldn't tell from the transcript.
But looking at this photo, what you're saying, is it within a degree of medical certainty?
Yes.
You can have your seat.
One question?
Are you done?
Yes, I'm done.
I'll allow it.
Oh.
When you answered the question at the previous hearing, was it also to a reasonable degree of medical certainty?
Everything I said in that hearing was to a reasonable degree of certainty unless I specified otherwise.
Thank you.
Just based on that, Your Honor, I get the last.
You do get the last word. Your witness.
But again, in terms of the context of that statement, even whether the statement is accurate, that doesn't change your opinion today looking at the photo,
No.
does it? Thank you.
Will this witness be released?
Yes, Your Honor.
All right, thank you,
Subject to
Doctor.
recall, but
Thank you,
Feel
Judge.
free to go, if you should get called back, you have to come.
Yes.
Thank you.
Your Honor, I don't know if you heard or not, I apologize, Mr. Escobar reminded me, I said subject to recall.
Right, I did. I
Thank
told
you.
him
Thank you
if
so
he
much.
gets called. Yeah. Approach. Ladies and gentlemen, obviously, the attorneys and myself still, we have things to talk about outside your presence. We're going to do that now and let you go. Again, you're going a little earlier than I had hoped, but please, it looks like Friday's going to be our late day. So if you can plan on that, looks like that's where we're going to be. And it's not because we're ending early today or any other day. It's just, that's the way we've got witnesses scheduled and things set up. So it's going to be unavoidable, I'm afraid. But just be prepared for that, all right? Any questions? All right, if you would, please remember my instructions during the recess. Don't do any independent research or don't discuss the facts of the case amongst yourselves or with anyone else. Don't watch the news. Thank you. I'll see you in the morning, 8:30, or whatever time you guys have to be here. Thanks. Dave, do you guys need any of the evidence, or can she take it up and process? We got another clerk coming in to sit for the rest of the hearing, but this one can take the evidence and start processing it for the day? Okay, all right, that'll be fine.
I most likely won't be here Friday.
Why not?
I'm a little busy that
Did she tell you yet?
No, I haven't.
Okay, she said she was gonna tell you. All right, how we doing, gentlemen?
I think you will be happy.
I'm glad to hear
Yes,
that.
Rick Escobar has agreed to 99% of what Mr. Martin has wanted.
Okay.
The only issue, am I right, Mr. Martin?
If you only had 4 issues, you agreed to 2.
Oh.
I went to law school.
I know.
No math.
Yeah, no math. We
There's
get that.
actually really one I'm not even sure that I'm gonna do, but because it involves the lighting issue. I can tell you very simply, this is the issue for Mr. Knox. Mr. Knox, because we knew that part of the evidence had to do with witnesses, when they were viewing bodies, they were viewing silhouettes. I think you actually remember that there were at least 2 individuals, I believe Friedhoff and I believe it was Hamilton. Both of them indicated that what they were seeing was a silhouette. What causes that silhouette is that backlighting that takes place when that light hits the individual that at this time was facing Mr. Reeves. And so we had Mr. Knox, who is a crime scene expert, test that in the actual theater under mid-1. It was everything that Mr. Knox did. We went to management and we said, we want to try to recreate the setting. I believe you actually sat in that theater with a mid-1 as well when we did the Stand Your Ground hearing. And so Mr. Knox, because of the fact that in a camera you can actually tell what the lighting conditions are in a camera. And so he wanted to capture that lighting and that silhouette that Mr. Reeves would be seeing if a large person like Mr. Oulson was standing in front of him. And so that was photographed. I think you remember probably in the presentation. It was part of the PowerPoint presentation that Mr. Knox had. And so it was to create that silhouette that not only Mr. Reeves was able to see in this whole process, but other witnesses verified that silhouette process. The only other issues that's tied to that same issue, and to be honest with you, I don't know if I'm going to go through the time that it would take to put this on, but Mr. Knox captured the various settings of light in the theater, mid-1 being the most important. And then he was able to do some measurements from certain points to try to capture what that looked like. To be honest with you, Your Honor, I don't think I'm going to do that. In fact, I can tell the court that I'm 99% sure that I'm not going to go and do that. I think it would probably be very lengthy, and I am not sure that the jury needs that. I think that they are probably smart enough to realize, that it was dark in there, and that they're going to have to take whatever that darkness is into consideration. But the silhouetting, I think, is very, very important, because I think that captures the perception that Mr. Reeves had, while he was in there. I believe, if you remember Hamilton's testimony, which was really great, and is the backbone of this argument, is that he said, no, I couldn't tell facial features. I mean, I couldn't tell whether, this gentleman had blue eyes, red eyes, green eyes, whatever it could be, or color of hair. He couldn't tell all that because it's a silhouette effect. And if you look at the silhouette effect, man.
Yeah, I'm going to show it to them.
Okay. When you're looking at the silhouette effects, that's what you're seeing. And it's not a highly scientific phenomenon. Everybody knows what backlighting is. It's just, what is backlighting, at that time. And Your Honor, I will tell you, honestly that, we tried numerous previews there at the theater in order to try to capture every, possible backlighting that there wasn't. There wasn't much of a variable at all. And that's one of the things that we checked with Mr. Knox. We wanted to make sure that, hey, this was pretty consistent, so that we presented to the jury that's going to be his testimony.
Okay.
So that's I think the only bone of contention is that one, because I don't intend to.
Mr. Martin?
May I approach John?
And Judge, we've briefed this, you've got, I think, our memorandum of law on this.
And Judge, as far as an exhibit for this particular hearing, I'm going to rely on the exhibit number 5 that I attached to the Daubert hearing that has all the photographs, but so you don't have to dig it out. May I just approach with it?
Yeah, that'd be great, thanks.
Right. You know what this is? It's all pictures. Yeah. And those are the ones that are in the PowerPoint. Okay. May I approach, Your Honor?
You may. Thanks.
Yes, ma'am. And 2 cases.
Okay.
May I go ahead and begin, Your Honor?
Uh-huh.
Your Honor, I've handed you exhibit number 5 that was attached to the state's Daubert motion and this particular issue.
Okay.
Those are all of the photographs that were taken by Mr. Knox during the time that they had an opportunity to go into Cobb Theater. Your Honor, what I did for you is Mr. Escobar showed you the PowerPoint presentation. Those are the ones with the yellow sticky. So the yellow sticky on there, just so you can find them, those are the ones that are in the PowerPoint. What I'd like to do, Judge, is we're in the same situation we are with playing the preview, that the discussion that we had as far as recreating and simulations. Now, I understand that this was done at Cobb Theater, but the other issue, and the reason I couched it in the form of the Daubert, is because of the scientific principles that have to be relied on in order for this to be fairly and accurately. And this is what they want to do. This is what Mr. Reeves could see. And that's what Mr. Knox testified. The whole purpose of this is what Mr. Reeves had an opportunity to see. So when you deal with that, what are you dealing with? You're dealing with someone's sight and the eyes, human eyes. And if you recall my Daubert brief, Judge, I went into great detail about how a camera lens is not the same as a human eye. And I gave, there must have been 5 or 6 articles that I attached that clearly indicated that that is not the case. And so this is a Daubert motion in which the defense has the burden of going forward and showing to the court, hey, a camera lens is just like the human eye. And a camera lens is going to reproduce that snapshot that a human eye can. And therein lies the problem, because we know that the human eye is very sophisticated. It is able to adapt to changes in light. It has a peripheral vision that captures ambient light. That's all the articles that I gave you, so explaining how the eye can absorb so much more light than a lens of a camera that is set by the aperture, and it is focused on that narrow beam, and that's what we have here. So the cases that I gave you, which is Pierce and Brown, deal with demonstrative evidence. And the requirement for that demonstrative evidence to be admissible, there has to be that type of similarity where it's not misleading or confusion. So we not only have the Daubert issue, where the defense hasn't proffered any type of testimony indicating that a camera lens can actually recreate what the eye can see, that they have, by presenting nothing, they have failed that part. It's their burden. I have given the court all the information it needs so that you can look at it and see that that's just not the case. So I understand why they can't bring someone in and say that, you know, a camera lens is the same as the eye. It can't. So once we have that Daubert, if that's not the case, then if you look at Daubert, because we have to rely partially on scientific evidence, then we look at whether or not it's actually an aid to the jury. If you can't meet that standard, because the eye's not the same as the camera, and we know that's not the case, then it doesn't aid the jury. Therefore, you don't meet the Daubert standards. The other one is that based on Pierce and Brown, exactly what is the criteria? If you're going to use a demonstrative aid, what does it have to be? Let's get past Daubert. We've already, talked about that, but they haven't even met those requirements. Again, because the camera lens cannot do it. Now, can we say, okay, it doesn't make any difference. It goes to the weight and not the visibility. Here's the problem with that, Judge, is pictures. Now, I've done a lot of cases. I know pictures. I have a case that I lost in 1990, the Latory boat wreck with Barry Cohen out at the Walsingham Bridge. I had one picture out there that caused the pictures, that's what they look at. They don't care all the explanation from NASA and everything, or we come in and it's what they see the picture, it's gone from them. So you put that in front of them with an expert that says this fairly and accurately represents the silhouette, then what it does is they take that to heart too much, especially when we all know in the courtroom that's not accurate. So when we argue, well, it goes to the weight, not the visibility, when you're dealing with an expert who's proffering it under the guise of being an expert and I know what I'm doing, then you run the potential of that carrying too much weight and they don't do their job and consider whether or not they're going to believe them or not. And that's the potential, and that's how 403 works. That's always been the potential we have to look at. To what extent is it so much they will just not do their function? If you run that potential, then you really got to think hard about whether or not you're going to put it in front of them. So in this particular case, we also have a situation where the background you can see is not the trailers that were back there. And that's why we get back to the Brown and to Pierce. We don't know at what point, a decision was made. Was it dark? Was it light? Was it dark? Was it half dark? Whatever it was, whatever the flickering on the screen at the decision made, nobody knows. So what they did is they took, and I believe all of them that they want to use or have a white background, they said, okay, this is a silhouette. This is what it looks like. And they put it in the theater. So you not only have that issue, but then you also have the issue, Judge, if you look at, I believe, 2 of those pictures have a red line that goes right to the chest. And I talked to is it Doctor? Dr. Knox about that. Oh, that's just a string alignment, it's not trajectory or whatever. Well, what is the jury going to do back there? They're going to see that red line in the picture. They're going to see how the mannequins are positioned. Now, we all know, Judge, that in a simulation, the defendant's version of the simulation can be put forth, and that's not my argument. My argument is that we don't get past the basic requirement of having it accurate enough for the jury not to be misled. So, and then you also have the other one. If you look at the very last picture that they want to do, you have the issue of forced perspective. And when I took the deposition of Dr. Knox, he said, oh, I was sitting there in the chair with the camera and I had it about where Mr. Reeves' eyes was, and of course, the nose looks so big and the cheeks, so you have several issues that cause the state's concern that it's not accurate. So that's the reason. That's the reason that they don't meet Daubert, and it's a 403 argument, and they don't meet the requirements under Brown and Pierce as far as doing that type of simulation. So I ask that they be removed from the PowerPoint.
Judge, let's think a little bit about this. First of all, not only did we brief the Daubert issue in this case, but in addition to that, we provided the court with all the transcripts of Mr. Knox's testimony. So the prosecution goes out there, they find some articles, they throw it on their motion, and somehow they think that that's gold. I don't have an opportunity. Remember, they're making the arguments that my experts can't, talk about some other study that took place because they don't have the right to test it through cross-examination. Well, let's think about this. He's told you, well, you know, this is a scientific fact. I gave you these papers, Judge. We don't even know who that person is. We don't know if he's competent. We don't know if he's incompetent. We don't know what school he went to. We don't know. We can't test it. And so, but he just assumes that whatever papers he gave you are correct. You know, he did that, I think, you know, with Judge Lewis in the other Daubert motions. It doesn't work that way. If you think that what we've put forth in the form of sworn testimony, including my client, my witness's credentials, then bring your own witness in. Bring your own person to test that. He has done none of it. And so, no, I think that he has failed miserably on the Daubert issue because he did nothing other than do his little motion and don't get some papers from wherever he got them, and that does not substantiate or refute my sworn testimony from a doctor that has specialized in this particular area of crime scene reconstruction. So, Daubert, I think, is right. I am very comfortable in relying on our memorandum of law of Daubert and our transcripts that we have met that. So let's talk about this. Mr. Martin, he will agree with you that we had lengthy discussions and depositions with Mr. Knox concerning the fact that Mr. Knox would sit in that chair, look at the scene, take a picture, and make sure that that picture actually reflected what he was seeing with his own two eyes. It's a forensic process that is used in photography. He was upset that when it did not reflect accurately and forensically what Mr. Knox was seeing, he would discard that particular photo. He got very upset. Well, where are those photos? I want to see the ones that you discarded. And Mr. Knox said, well, Mr. Martin, if they don't accurately represent what I am seeing, I am going to discard it because I'm not going to use it in a court of law under any circumstances. So this is a demonstrative aid that is so important because their own witnesses have demonstrated to this court that that's exactly what they were seeing. They were seeing a silhouette. Now, we can assume that people know what that means and what that looks like, but we shouldn't do it in a criminal trial, especially a murder trial. We shouldn't assume that these 6 people, or 10 as they are right now, can actually understand what a silhouette is and what it does to the human eye as far as what you're able to see. We're not and Knox is going to not say, hey, listen, this is exactly, you see that face right there? That's exactly what he saw at the time. It's the effect. He is showing the effect of that backlighting on a human body when it was facing Mr. Reeves. That's about all I can tell the court, Your Honor. I think that we're on solid basis here. Mr. Knox is not going to say anything, in my opinion, that's going to be in the form of an opinion that this is exactly what someone sees in a silhouette. I don't think anybody can do that. But I think that certainly the concept of silhouetting and what happens in the silhouetting process is so important for this jury to understand because, again, this criminal case is so unique in that it's Mr. Reeves's perception that's important. We all know, and I know you're going to get mad at me if I say this again, the danger doesn't even have to be real. Think about that. The law does not punish someone as long as they reasonably believe that they're in imminent danger of death or great bodily harm. And the law says, you know what? You could be wrong. The danger didn't have to be real. It's the perception. This case is all about perception. And so we've got to be able to give the jury evidence of that possible perception with reference to silhouetting. It's as simple as that. You know, that's my argument. I think we've briefed, you know, this issue thoroughly. I've conceded to everything else that Mr. Martin wanted. You know, not because he was necessarily correct, but because, you know, I've got to necessarily try to tailor my case as we're getting down to the end to what needs to be presented before the jury.
Could I have 5 minutes?
Yes,
If I promise to keep it 5 minutes.
go ahead.
Judge, the articles are in the Daubert motion so that I can file a legally sufficient Daubert motion. Once I do that, it then becomes the burden of the proponent of the evidence to refute that. That's Mr. Escobar. Now, what they've done is they've ignored that. and they've made a choice, we don't care about that. We're gonna rely on Mr. Knox to come in and say, okay, this camera, I looked at it, and it's what I'm seeing with my eyes, therefore, it's correct. And we know that's just not correct. So what we're doing, and Mr. Knox then says, and he has said, this is what Mr. Reeves saw. So that's where we have the problem, is that it's Knox's testimony that Mr. Reeves saw that. Well, what we know about silhouetting, what do we know? We know it's done with the human eyes. And silhouetting is dependent on the differences between light in the background and the foreground. And so if your eyes are different than the camera because of all the ambient light around, then we don't know if there's a silhouette at a particular point in time based on the light in the foreground and the background and the ambient lights from the sconces on the side. There's the problem, is, okay, we want to show this is the silhouette, this is the silhouette what Mr. Reeves saw. We can't do that because the silhouette is based on all of the light that the eye takes in and the camera doesn't. And once you get to that point, then it's misleading to the jury. And so I disagree strongly with Mr. Escobar that, you know, I needed to do anything. I did a legal, sufficient Daubert motion that they chose to respond in a certain way and they failed because they didn't address those issues. They simply said, Mr. Knox looked at the camera. That doesn't mean it. So that's my 5 minutes, Judge.
Judge, I have 30 seconds. In a Daubert motion, you make allegations. Prosecutors make allegations. But those allegations, I have to refute. But you don't take those allegations as true because guess what? They've got to prove it as well. In other words, they can't throw, some article up there and say, okay, Judge, guess what? You have to believe that article. It doesn't work that way. The problem that they have is that they don't have an expert that's going to be able to say that this particular demonstrative evidence that we're introducing, that there's anything wrong with it. It's demonstrative. It's trying to give the court, the jury, some indication of what silhouetting is. And so he's wrong. Somehow he thinks, yes, you can make an allegation and it shifts the burden. But just because it makes the allegation doesn't mean that you have to, the judge has to conclude that what he's given you in those allegations are true. What we've done in sworn testimony is we have refuted and we have substantiated the reliability of the silhouetting process that we intend to introduce.
All right. As far as the Daubert motion regarding Dr. Knox, the state's indicating that defense failed to refute your allegations about the accuracy of the human eye versus the camera, primarily, that's one, and then that there's no accurate recreation of the backlighting.
Correct, that's the two.
And defense is indicating that they want to use these photos as demonstrative aids.
Which is what Pierce and Brown goes to.
Right, and so I'm glad you brought that up. On Pierce, the state was allowed to use styrofoam heads as demonstrative.
Kind of like we did with the skeleton.
Yeah, but a little more involved, without a doubt. I mean, they stabbed it to recreate the stabbing of the crime. My question on that, well, I got a lot of questions. I'm not positive that the defense has not satisfied Daubert, the statute. The prongs in the statute, there's 3 basically, but Dalbert, obviously, there's 4, but statute is just codified Dalbert. So how is Pierce distinguished from what the defense wants to do here? How is it okay, how is it a styrofoam head is similar enough, but these, and I'll say, you know, in scientific approach to these photos, you know, obviously neither of them are the exact recreation. Clearly in Pierce you couldn't have that, but so, you know, you gotta go there. They're not the exact recreation. How is Pierce different from what we've got here? Now, I understand the backlighting question. It looks like there's several different backlighting issues addressed in the photos. But my first question is, how is the Dalbert requirements not satisfied by Dr. Knox? Which prong is lacking?
The prong that is lacking is that the camera lens can't capture an image exactly like an eye can. And he admits that in the depot.
Okay.
And just so that, I know it's a little piggy, the styrofoam head is brown, just so the record's clear.
Oh, okay, sorry. Thanks. No, I appreciate that. I
I
was looking for it again in Pierce and I didn't see it. Thank you. I appreciate that.
Right, and
Yeah.
if you want me to comment on that, I will, but you had another question about how they don't meet, and that is I apologize for saying
That's
that, and that
okay.
is the issue, because their own witness indicates that it doesn't. And then he goes on to say, but this is what Reeves had an opportunity to say. So he agrees that the lens is not like the eye. He agrees that he can't capture it, but he wants to tell the jury, this is what Reeves could see. This is his perception. And so there, it's a problem upon a problem. That's why I ran the motion to keep it out, because that is not, he can't say that is what Reeves can say. He's admitted that in his depot.
Okay.
So I ran the motion for the sole purpose of making sure the court understands that we have an issue under Dalbert. That's the scientific part, the camera lens, how it works, how it functions, how it captures light in an image. It's not like the eye. And their own expert admits it's not. So that's why it should come out.
And I read your articles, and I understand the defense's argument about that. It's been a little while since I read the articles. It does seem to be almost common sense and pretty straightforward in the articles that, you know, a camera is just not as good as an eye. What about that, Mr. Escobar? Is that what Dr. Knox is going to testify about?
Oh, yeah, he's never going to say that the camera can capture exactly what the eye does, but we have that phenomena in photos.
Sure.
You know, because remember, the standard for photos is fairly inaccurate. It doesn't say exactly what the eye. So then what you're doing then, if we're going to have that prohibition, let's not introduce any photos. Because if in fact the eye is seeing something different and is not exact to what the photo is capturing, then we've got a big problem. That's the problem, is that in our world, in our scientific world, no, a camera can never capture exactly what the eye could capture. But if it fairly and accurately depicts what is taking place, then that is sufficient under the law to have it introduced. And all we're doing in a demonstrative capacity is we're not saying This is exactly what Mr. Reeves saw throughout the entire encounter. What we're saying is, hey, this is the backlighting effect that takes place when you have a backlight on an object, or a human being or a mannequin, standing in front of Mr. Reeves. This is what you could possibly expect under the circumstances. And that's what Knox is going to say. He's not going to say what he just told you that Knox was going to say. He is not going to say that. I realize that, you know, where Mr. Morton gets a lot of his concern is through his own questions. And I don't fault him for that, because he's asking Mr. Knox, well, Mr. Knox, you know, what is your personal opinion about it? And Mr. Knox is going to say, well, you know, I think that based upon the size of the mannequin and based upon, you know, the lighting that was being, that's probably what Mr. Reeves was actually seeing at the time. But, you know, and then he puts that in his motion for a motion in limine. We were never going to ask that. Just like we were never going to ask, you know, Bedard some of the questions that, you know, he thought we were going to ask, but he just asked that in depositions. And so, you know, if you want Bedard's, you know, honest opinion, he's going to give it to you, but it doesn't necessarily mean it's admissible. So you've got to look at this issue of the camera versus the eye in the same light as we look as a camera and a photo. And for as long as I've been practicing law, we have allowed photos to come in under that particular standard because, yes, I think Mr. Knox told you that it's impossible for this machine to, you know, capture it to 100% certainty, but it's pretty close. I can tell you that.
Okay, and I understand your argument. Of course, we all rely on the photos and probably state more than anyone else. However, it's not typically from the standpoint of someone's perception.
But you know, this is demonstrative. We're not introducing
I know,
it.
I
It's a little
know.
bit, it's a relaxed standard.
I know, and I'm keeping that in mind. So, I think that the prongs of the statute have been met through Mr. Knox's testimony. And I feel that any issues that state is complaining of can be addressed on cross. And they are demonstrative, they're not going back. And I think these are a little bit different than the previews playing, in that what I'm seeing is that there are various different lightings. And again, that issue can be developed on cross. And as long as the testimony isn't elicited that this is what Mr. Reeves saw definitively, then I'm not seeing a great distinction between this case and the Brown case, where, you know, we all know that demonstratives are just that, and to exclude a defense witness's presentation when after reviewing everything, I feel that the prongs of Daubert have been met. I don't have a strong basis to do so, other than the argument about the eye versus the camera, and that is compelling, which is why Dr. Knox will not be able to testify that this is exactly what this is what Mr. Reeves saw, and that's not going to happen, right?
That's not going to happen.
I think it's a fair and accurate portrayal of something that this expert is able to testify about. I don't think it's misleading to the jury. So I'm gonna rule in favor of the defense on that one.
Judge, just so that you know, for Mr. Knox, we're not going to elicit from him any type of, trajectory or ballistics, even though he's qualified. I think Glenn will agree with me that he's very qualified to do that. We're not gonna do that because we don't think it's needed at this point in this trial. We don't think that's gonna be a lengthy process, and I'm not sure, this is not a whodunit, it's.
Right, exactly. I don't know why that would aid the jury in their decision.
The other issue with Mr. Knox was his interpretation of the video. I've run that by Mr. Escobar. He's assured me that he's not going to do a running narrative of
Okay.
The only thing that we're gonna talk on the video, and we've talked about this, is that there was an issue that came up on either illuminating or reflective. It could have been the phone, it could have been the shoe, and what Mr. Knox tried to do with Mr. Koenig in order to try to find the source of those lights. And that's about the only thing, but he had to look at the video in order to see that there was either a reflective or illuminating light that we had to find out the source of.
Okay.
Judge, my discussion with Mr. Escobar was that they went into Cobb Theater and Mr. Knox was told there is an issue about whether or not something in the video was illuminating or reflecting. Not that he's viewed it or whatever, because he's already testified at the immunity hearing. I saw a reflection and I saw something illuminating and I saw something that was a shoe. So he's already said, I think there's two things. And Mr. Escobar, throughout the whole trial, to his credit, he's been very careful to say illuminating or reflecting, not is one or what the object is. So I think if it's couched, even leading if you want, that a point of interest while we're here was to determine whether or not a point of interest in the video was either illuminating or reflecting. That would be the proper way to do it. I'm suggesting to the court would be the proper way to do it. And then he can say, yeah, we tried to do it and we couldn't do it. So, he does say, I watched the video and I saw this and you know what I mean? So I think we can do it very cleanly, like we have been doing the entire trial that way, and I don't have a problem with that. But also during his previous testimony, he went over, I didn't see this, I didn't see that, I didn't see the hand up, I didn't see the yelling. There's like 12 things that they went through. So I'm being told that he's not going to do anything with the video about what he saw or he didn't see.
Okay.
So with that understanding, we don't have to argue that part. We don't have to argue the trajectory. Mr. Escobar can tell me tomorrow if he's going to put in those other photos that he doesn't know if he's going to use, and you've already ruled on the magnet. So the only thing we have left with Knox is the seating photos. Our argument is the same, is dim 1, dim 2, camera doesn't affect the eye.
Judge, I'm gonna save him some breath there. I'm not gonna do it.
Okay.
I'm not gonna do that, but I do wanna talk about this issue of the illuminating or reflective. We presented to Mr. Knox the fact that there was an issue here as to whether that illuminating or reflective light was either a phone or a shoe. Could be either. I'm the first one to tell you that, it could be either. Part of the problem that we have in trying to determine whether it was one or the other, is because everything was dismantled over there in the form of the actual machinery. Had they not, we feel very comfortable that we would have been able to tell this court what it was. The problem is that I don't want to hide that fact that we were trying to determine whether that reflective or illuminating light was either a shoe or a phone, because that's the truth. And Mr. Knox, in his crime scene investigation, had to consider those two items as whether they were or they were not. So I'm not gonna get up to this jury and say, well, we had a source that we were concerned about, which was either reflective or illuminating, and not tell them what those two sources were that we were concerned about. Those were the only two sources that we were concerned about, and so that's the truth. And so I'm not going to tell this court that I'm going to get up there and say, I've been very good, I think, at making sure with Mr. Koenig that, I was going to be identifying reflective, illuminating. Because although Koenig was there to make sure that everything was going to be done videography-wise, it was really Knox and Lacey, which was Mr. Koenig's partner, that were instrumental in setting everything up for that very late night that we were 2 o'clock in the morning at the Cobb Theater. So I don't see any harm in me, in Mr. Knox saying, that, he was trying to find out whether the source of reflective or illuminating light had anything to do with a shoe or a phone, because that's the truth. That's exactly what we were trying to figure out.
What about that, Mr. Martin?
We can be here all day, make a decision, Judge.
I think that is fine. It has been clear throughout the trial, and I thought maybe I've just imagined it, but I think I've heard that it might have been a shoe or it might have been a phone somewhere, sometime. Haven't I?
It's always been, we went through great lengths, both the prosecution and the defense. That's been the
Okay.
issue.
So I think that's fair, that's what he was trying to do and was unable to do so.
And Judge, let's assume that it's a shoe. It doesn't refute, this is the crazy thing, it doesn't refute that the phone didn't fly, because if the phone was flying with the black facing the camera, you wouldn't see it. And if the screen of the phone at the time it was flying, it wasn't illuminated, you ain't gonna see it either.
Right.
So it's not like, there's this incredible, issue that we could resolve. We could have resolved it, but we weren't able because of the DVRs.
Okay. All right, one last real quick thing that I neglected to say about the photos that I agree to allow as demonstratives. The red line, I see in some of them it's very prominent,
Yes, ma'am.
but most of them,
Just the yellow tab ones, Judge.
yeah, there's.
Your Honor, can we have Mr. Knox say that had nothing to do, or the only reason he was doing that, it's my understanding, was that, he wanted to make sure that the positioning, because I was there, and Mr. Michaels was there, we wanted to make sure that the positioning of Mr. Oulson would have been in the different locations. If you look, they've actually put Mr. Oulson in different locations. That's why you see, different effects of the backlighting. And so I think that was only to get a directional, but I can certainly ask Mr. Knox, and Mr. Knox will testify, hey, those things have nothing to do with what I'm testifying about here today.
All right, it's really only prominent in.
Because if not, we're gonna have to, I don't know what
Yeah.
the solution is.
Right, I don't.
Judge, it's the impression that it gives. And I know how photographs, once you get back there, they start thinking or whatever, and it doesn't matter what the witness says. So, that's a problem.
Well,
But you've already,
Yeah, I don't find it to be a problem. The first one in particular, it hardly shows. And so what if they think it's a trajectory, which I personally that wouldn't come to mind, but you're right.
because it's at an angle, Judge, that's the problem.
I think most people wouldn't give it much thought, and if they did, I don't know. I don't see much, I don't give it any real credence. That's just my findings for the record. I'm not gonna say that the jury absolutely will not take anything from it, but from my humble common sense standpoint, it almost would have to be pointed out in a couple of them to even be seen or
Well, you know this
noticed.
is going to be up on their whiteboard, it's 4K, it's not going to be the.
I know,
copy.
I know.
I've got a solution for that, just so the court knows. We're going to have colors made of those. We're going to introduce into evidence the actual colors. We're not going to introduce the thumb drive. The thumb drive is for demonstrative evidence, so, whatever the court, there's some other pieces of evidence there. If you look, I can't introduce that entire thumb drive because it's demonstrative. Some of it is demonstrative. Some of them is evidence. So I'm getting actual photos, replicas of that, to actually introduce, because there's a lot of measurements, as you can see, that I want the jury to have. And so all those measurements that you see there are gonna be in the form of a photo, but we're gonna show it also on the big screen. So what I'm not going to introduce into evidence is the demonstrative evidence of the mannequins. That's just gonna be on the thumb drive.
We haven't even discussed that. So I was led to believe this whole thing is demonstrative, it's on a flash drive, he's gonna use it, so.
How can measurements be demonstrative?
I don't see any measurements in here.
Yeah,
Yeah, there are.
Yeah, there are. There are
In
measurements.
the very beginning,
Measurements can't be demonstrative.
well, the presentation is demonstrative. There's measurement pictures, there's pictures of, the right hand of Chad Oulson, there's pictures of the fingers, there's pictures of NEO, pictures, entries,
So Judge, this is what I told him about the pictures of the wounds. Mr. Knox is highly qualified to give trajectory, to talk about stippling, to talk about all that stuff. I don't want to dismantle this PowerPoint if I don't need to. And so because I don't want to dismantle the PowerPoint, I told him, I said, look, I'm not going to go through all this trajectory, I'm not going to go through this ballistics, but these pictures are already in evidence through him. So that they're harmless. They're harmless. Knox is not going to get up there and say, well, let me tell you about this wound. No, it's just part of the pictures that he considered in doing his crime scene reconstruction. So I told him, I said, you want those pictures out? Then I'll have Knox do his entire ballistics and reconstruction, and we'll put it on. I don't think it's necessary for my case, and I've taken that position. But we can't fight about things that are already in evidence that he introduced himself. It makes no sense.
my whole argument's been the mannequin pictures. I'm not arguing,
Right, the other stuff.
If he has other pictures that he's gonna put in, fine, but I didn't think the PowerPoint was going to go in as evidence. That's
No,
what
it's
I got
not.
from it.
It's not. It's demonstrative, but I'm gonna use photos from the PowerPoint on the measurements that I am gonna get in. And he's gonna lay the proper predicate and off we go.
Yeah, that's fine.
All right, all right. There are no measurements in this stack,
No, Your Honor.
not that I can see. So,
We set you up for failure, and I apologize.
thank you.
May I take this back?
Yes, you can have that back.
This is mine, so I'll put it back.
Oh, yeah, I got it. Okay, so yeah, this is,
Did you get the measurement ones?
Yeah.
I had
okay,
a question about one of those.
now I see the measurements.
Yeah.
Okay,
And those were all that he took himself with us there at the Cobb Theater.
that the state failed to take, that the
They took some-
sheriff's
and-
office failed to take any measurements. Isn't
in
that right?
honesty-
Were you gonna bring that up
No,
again?
Your Honor, in honesty, they did take some measurements, maybe most of them a little late, but they did take measurements.
Okay.
I have a question on
I know.
on two of those pictures with the measurements.
Okay,
I'm just going from memory. One of them was a demonstration of someone leaning back in the chair, obviously to simulate Mr. Oulson putting his arm on the chair and leaning back, and what the distance would be if the chair leaned all the way forward. So my objection with that would be, and I wasn't here for the discussion about the dummies and silhouettes, but I would think that all of those arguments would be the same, which is very similar to the movie trailers, which is, this is an attempt to recreate a scene that can't be recreated. You can't figure angles, you can't figure where everybody was, you can't determine the lighting conditions, you can't determine the sound. There's no sound for this argument, but it goes back to recreating the entire environment in the theater. So the demonstration of whoever that is, I'm assuming it's Mr. Knox, of pushing back on the seat, we don't know how far Mr. Oulson was back. He could have just been touching the seat. So it gives the jury the impression that the distance has been closed based on that particular picture. So I would say that picture should not be allowed. The other picture, I can't remember if it was 3 feet 8 inches and it shows distance from one chair to another chair. I don't know if that was to represent Chad Oulson's chair distance to Vivian Reeves's distance, or it was a diagonal measurement, so it went from Chad Oulson's chair all the way across the stripe of the left-hand side of Curtis Reeves's face. I don't remember if I actually even saw a measurement for that, which would be curious, but if there's one in there, I'd like to take a look at it. But, you know, any of these things, I understand they're demonstrative aids, but demonstrative aids still cannot be misleading under 403. No matter what, it has to pass 403. And again, I wasn't here for the knots and the silhouette argument, but, you know, just to add that to the record, you know, if we're trying to simulate how the defendant viewed something through a camera that can't simulate the human eye, I would certainly think, and unfortunately, I wasn't here, so I don't know if there's a 403 argument made. But how you can have someone sit in a seat with a camera and then make an argument to the jury that looking at this photograph adequately represents what Mr. Reeves observed of a silhouette of a mannequin that doesn't have the same shape and design of Mr. Oulson, I just don't see how that would aid the jury in anything. If anything, it would mislead and confuse the jury, but it's not so similar to either of the people. I mean, I would submit that if we took a picture and sat down with a camera and said, look how easy it is to see Mr. Oulson, someone would say, that's crazy, you can't replicate how someone saw Mr. Oulson on that particular day. You couldn't do that, and I would agree, which is why I would never try to do that.
Judge, getting back to the measurements, and I, with all due respect to the prosecution, their crime scene investigation in this case was a train wreck. They didn't take proper measurements, they didn't get any guidance, and so now, what Mr. Knox is going to talk about is this is what you have to do in a crime scene, because you have to take pictures of measurements, not only in the seat in the upright position, which we did, and we're going to introduce that, but we're going to take pictures of that seat when you're pushing it back, because if you remember, there's some testimony here that Mr. Oulson is coming over the seat. And so if he's coming over the seat, and if you remember, there's even testimony that they didn't even know if the seat was down or if the seat was up. In other words, some of those seats pop up. And so you have to take all these measurements so that the jury understands what the measurements are for every possible scenario. It's the jury that's going to decide, you know, whether in fact there were certain inches that were available for Mr. Oulson to strike, you know, Mr. Reeves. We know that certainly he got really close because Mr. Reeves had a popcorn in his hand and he grabbed that popcorn from Mr. Reeves' hand and shoved it in his face. So those measurements, I don't know, you know, what Mr. Rosenwasser is talking about, because in every case that I've had, crime scene comes in, they do all the measurements. The more measurements, the better. Because these folks here need to know the layout, they need to know the measurements of that theater so that they can then determine what really took place in this case. So none of those measurements are prejudicial. We've got measurements of the seat up, we've got measurements of the seat down, we've got measurements of the back upright, the seat up, the seat down. We've got it every which way possible, because we're not telling this jury, hey, listen, you know, this is exactly what was happening at this point in time, but we're giving them the parameters of space. Space in self-defense cases is critical. Now, Mr. Rosenwasser, in opening statements, you would think that the distance between Mr. Reeves and Mr. Oulson was half a football field, because he was talking way in the row over there. You know what I mean? Well, it's not way in the row over there. It's a very, very tight space, and the jury needs to know the diameter of the entire theater. In fact, you know, Mr. Martin and I actually got actual specs, engineering plans for that particular theater that was given to us by the theater. So it is what it is. I frankly have never had a prosecutor argue against measurements within the theater and within the space of where the incident happened, because that happens all the time. I've been doing this for 37 years. I can't imagine any murder case that I've had where that hasn't happened, other than this one. And I think, you know, we showed the court why we thought that this crime scene investigation was not done appropriately.
I wasn't objecting to all of them, it was that one. I mean, of course we would want the measurements in.
Well,
I mean,
that seat
I was
goes
just saying
back.
about that one.
The seat goes back, so you don't want to tell the jury, don't tell the jury the seat goes back.
You can't say how far the seat was back. You can't mislead the jury.
Sounds like cross-examination to me, but that's just me.
Yeah, I see we've got a 3 foot 8 inch and a 3 foot 2.5 inch. Basically the same kind of thing.
And there's gonna be many more, Judge, that we're gonna be introducing with Mr. Knox. They have them all. They have all of Mr. Knox's measurements, so it's.
All right, this all sounds like contemporaneous objections, because it's pretty specific, but in general, I don't see a problem with it. From a Daubert standpoint or a 403 standpoint, what I'm looking at here. I don't think it's confusing, and if there is clarification needed, that's can certainly be accomplished on cross, I would think. So I don't see an issue with these photos. All right, what else?
I'll prepare an order for the Daubert motion, dealing with that issue. The mannequins was a separate motion in limine filed in 2017.
Okay.
I'll prepare an order for that. I'll withhold on the order on the other motion in limine filed in 2017 regarding the seating, and or I can do an order that says that Mr. Escobar says he's not going to use them, therefore it's moot.
Well, yeah, because that's what I'm concerned about, because, I mean, my order on the Knox-Daubert motion is going to be similar to Judge Lewis's in that, you know, it's not very specific, but primarily it's in recognition of the things that Mr. Escobar is not going to elicit, so I don't need to.
Right, so I could do the Daubert as being, the video is moot, the trajectory is moot, all these are moot. The only thing that was heard was the backlighting and denied. I mean,
right.
That's all we need.
Right.
It was denied and that's
Right.
reserved for appellate. So I'll do it that way, and then with the motion eliminating regarding the backlighting is a separate issue.
Okay.
It's out there, that'll be denied, so preserved, and then with the seating, if Mr. Escobar says he's not gonna use them, then, that can be reflected that it was moved.
Okay.
What seating, what do you mean seating?
You told me you weren't gonna use the, general seating area.
Or you're talking about the ones where it was the lighting conditions and
Yeah.
seating, I'm not using, but it's really lighting conditions, that's the issue there.
That's why I said, the general seating, lighting, my second motion eliminating.
Yeah.
I'll put in the order that in open court, not gonna use, therefore it's moot. And that will have that
Okay.
order taking care of that.
All right. Excellent. Anything else today?
Yeah, I gotta review a video.
I know.
Among other things.
I know. Yeah.
I don't think, if you, I think maybe Mr. Michaels and I can talk just a little bit more about Mr. Vernard.
Okay.
We're close. My math is probably a little better than a lot of individuals in this room, so we're more than halfway there.
I like that.
He just threw me under the bus.
No. We are more, there are a couple of issues, and there may be issues we may have to discuss with the
Okay.
board. I'm gonna talk to my expert this evening,
Okay.
just to get his input on it. He's an expert,
All right.
and he's testified, and then we can, whatever we can agree on, then we'll address it with the court.
All right. And
He's not testifying tomorrow, correct?
But oh, yeah.
Probably late.
Yeah.
Well, then that's the problem. We've gotta have these issues resolved.
we can work
We can do it
on
in the
lunch, or lunch,
Yeah, or lunch, that's fine.
lunch, yeah.
Lunch.
We expect tomorrow, just so the court knows our schedule, Foley, Knox, and Bedard.
Okay.
I don't think we'll get past those.
Right, I think maybe Foley and some Knox before lunch,
That's what I'm hoping.
and then Knox and Bedard in the afternoon.
And what I'll do this evening, once I'm able to speak to Mr. Bedard, I'll go ahead and shoot Mr. Martin an email,
Okay,
because I know what his main concerns are, and the ones that we kind of are, I know the ones that we can agree on right now. Other ones I told Mr. Martin I was unsure of, I'm pretty sure we can agree on. There's probably just two issues. One has to do with an objection to the testimony being cumulative as it refers to self-efficacy because of Don and Cohen, so I want to be able to flesh that out more, so I
okay,
can articulate it better. Another issue has to do with some of the differences between instructing police officers, the force continuum, and those kind of things that the court heard. Well, that's right, Judge Lewis, I think, heard that motion, but anyway, so those are things that, we're not too far apart,
okay.
but we're not close enough on those, so we may have to discuss it.
I have reviewed the entire transcript
Okay.
of Dr. Bedard's testimony for the Daubert, so,
And so did I, and I provided you not only my motion, but a reply,
right,
because there was no oral arguments.
right,
Right, and it was granted, but again, subject to
Right.
evidentiary issues,
Right.
like, he's not gonna get up there and say, I
right,
looked at, Mr. Reeves was reasonable because of my training and his training, or I looked at the video, I mean, all that stuff, we agree on the big stuff.
Right.
It's that cumulative and maybe some other issues that we'll.
okay, that's good that you're
Okay.
getting close. All right, so we can plan on doing that at lunch tomorrow, so maybe bring your lunches and we can have a brief lunch and some.
We frequent Oga's in the morning.
Yeah, there you go. All right, shall we break for now? I think we've had enough for one day. All right, thank you, everybody. We'll see you in the morning, 8:30. This is, Mr. Martin, you've got stuff up here. I don't need that, it's off, we're off. Thanks.